Okay, we're live.
All right. Good morning, everyone. I'd like to call to order the Judiciary Committee public hearing for March 18th, 2022. We certainly are hoping for a slightly shorter public hearing than our last one, but we do have about 35 folks signed up today. So let's get into it. First up will be Judge Beverly Strike-Cafalis, the probate court administrator. Judge Beverly, good to see you.
Good morning. Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and members of the Judiciary Committee. Thank you for giving me the opportunity to testify this morning. I am, for the record, Judge Beverly Strike-Cafalis, probate court administrator, and I'm here to testify concerning two Senate bills. The first is Senate Bill 361, which is an act concerning the probate court operations. It sets forth 7 sections, which are largely technical and address issues from changes that came out of the last session mostly. I'd be happy to go through each particular session or section of our operations bill. I have submitted written testimony that really highlights each of the provisions, which I believe are fairly straightforward, most of which actually address the Connecticut Parentage Act and are provisions that we have reviewed with the Judicial Branch, as well as some of the jurisdictional issues overlap. I'm also here to testify in support of Section 1 and 2 of Senate Bill 424, an act concerning real estate and probate courts. I take no position on the public policy position provided for in Section 3, but I do alert the Judiciary Committee that it distinguishes between an automatic release of the estate tax lien from the probate fee lien, which is important because the probate fee is obviously the main source of revenue for the probate court operation. So I think that distinction is important. I'm happy to limit my testimony thus far and let your day go on, hopefully as quickly as you hope, and answer any questions.
Got a question from Representative Fishbein.
Thank you, Mr. Chairman. Good morning, Judge Strike-Cafalis. I just wanted to ask you about the second bill that you were testifying to, SB 424, and in particular, the section at the end, I think it's in Section 2, well, it's basically the whole of Section 2. Can you just explain what's going on there?
I'm sorry, which section are you inquiring?
Section 2. Section 2.
In essence, what that is providing for is that right now, 45A 113A provides for the probate court to issue a refund when we realize a refund is due, obviously. And this just supplements it that no person is entitled to a fee when the basis was for the succession tax. The succession tax provisions, as you know, have been repealed. And so any probate fee that would have been paid from those tax returns have now passed. I would say this is not our proposal. I'm here merely to support the provisions, Section 1 and 2. And I think the Connecticut Bar Association and the Department of Revenue Services have largely worked collaboratively on the language here.
Okay, I'm just trying to figure out how it would apply, because certainly when we're saying to someone or to the general public that you're not entitled to a refund, I think it's important that we know that somebody somewhere has a potential colorable right of a refund. And through this legislation, we would be precluding that. So I'd just like to know a little bit more about how this could happen. I mean, is there legislation that's already superseded this? What are we doing here?
The intent of the proposal is so that individuals who paid a probate fee as a result of the succession tax filings that were previously the law would not now be entitled to a refund of those fees now that the succession tax has been repealed. So it's not a situation where two people may have paid the probate fee and there's an overpayment. It just ensures that as a result of the full repeal of the succession tax, that any probate fee properly assessed and paid when the law existed would not now be able to come back in and say, now that it's been repealed, I want my probate fee money back. It's to ensure that the repeal of the succession tax does not impact otherwise properly assessed and paid probate fees.
Okay, so do we know like how much money is out there that people could claim they are entitled to a refund? Are we talking about millions of dollars, or are we talking about?
Oh, not at all. In fact, what our system does on a regular basis is when probate fees are paid, they are assessed based on a tax return filing or the inventory. And I'm talking predominantly about decedent estates. And when there is an adjustment, for example, an amendment of the tax return, or if it's taxable, a reassessment by the Department of Revenue Services, our system automatically will calculate what the proper fee is and start the process to refund it. It's done as quickly in real time as possible. We certainly would not want any taxpayer or constituent to be waiting for a refund to which they're entitled. So we have an automatic review process and issuance of those refunds.
No, what I'm referring to is individuals that possibly could apply for this refund that we are now precluding that. Do we know collectively how much money is potentially out there that could be claimed against? And you may not know. I just, 10,000 people are going to contact us and say, you shouldn't have done this because I was going to put it in for refund. That's one thing, but if it's two people, that's another thing.
There should be no individuals entitled to a refund as a result of a succession tax return filing. This language addresses to ensure that the repeal of the succession tax does not retroactively entitle someone to a refund when the basis for that fee initially was proper and accessible because the succession tax existed at the time. I know it's a little confusing.
No,
but the bottom line being, there should be no one entitled to a refund on a succession tax return. That's not what this language seeks to impact.
Okay, so individuals are different from estates. So is there any entity and or estate that may be entitled to a refund that we're precluding here?
No.
Okay, that's fair. So on the topic of refunds, on what basis does the probate court review its policy with regard to refunds of probate fees?
Well, again, in the decedent estate, the fee is based on the gross taxable estate reported on an estate tax return. There are times when a fiduciary will amend the return because new evidence of or after discovered assets have arisen, or if it's a taxable estate, sometimes the Department of Revenue Services may assess the value differently. And so when those amendments are filed, our system, when those numbers are inputted, calculates if there has now, as a result of an amendment or a reassessment, changed the probate fee. And then the refund is generated through our system.
Yeah, thank you for that. I was talking more globally, and let me give you the situation, okay? Because it has to do with refunds. I recently had a case, two matters almost exactly the same, filed in two different probate courts. One probate court issued hearing notices before the other. that matter was withdrawn because the parties agreed to have it in the other jurisdiction. The probate court fee under your rules apparently is non-refundable. And plus the parties got charged for putting out the hearing notices. When does that, in my opinion, inequity get reviewed similar to what we're doing here today on a refund issue?
So the probate fees are all established by statute. And there are a number of charges that are properly assessed against a petitioner or an estate. I'd be happy offline to look at the specifics of the cases you're considering or reviewing, but in general, it sounds like the charge was properly billed. So a refund relates to an improper charge or an overpayment. It's largely overpayments, where an individual may, as I indicated on an estate tax return, have changed the value of assets so that the fee initially assessed and paid is now subject to adjustment under the probate fee statute.
I understand. I was informed that it's the probate court's policy and rules and not the statute. So yeah, we can have the discussion offline. I don't want to, stray that far from, but I don't think that's necessarily fair when the parties agree to withdraw a case for the economy of the probate courts, really. But anyway, I thank you, and thank you, Mr. Chairman.
Representative Doucette.
Thank you, Mr. Chairman. Thank you, Judge. I just wanted to confirm that this was, in fact, just the succession tax that we're talking about in this bill. So pre-2002 filings, is that correct?
I think it's 2005, but yes, it only,
Okay.
to my knowledge, relates to those succession taxes. The provisions in 424 that relate to Section 1 and 2, though, are an automatic expiration of, Section 3 is the automatic expiration of other taxes, I believe, but that I'm not opining on that policy that's set forth therein. 1 and 2 would address any kind of tax lien where, as you may know, this is a bill that's arisen in the past, where in essence, an innocent purchaser of the property has acquired title subject to unrecorded liens. And it's a mechanism so that they can obtain clear title, even though they may not have full knowledge of the value of a decedent's estate.
Right. Okay. But the Section 3, again, for the succession tax purposes, I mean, it seems to me the only, and I can't even imagine such a scenario, but the only scenario would be someone, like you said, amending a return back pre-2005 to potentially remove assets that, or perhaps something was miscalculated or something. And I just can't imagine, it's exceedingly rare it would be the circumstance in which somebody be doing that. So that being said, what's your understanding for the reason for this? That this change would be necessary as requested by?
I would defer to the Commissioner of Revenue Services and the Bar Association. This is not our proposal. I'm merely offering an alert on Section 3 that it does distinguish the automatic expiration of only a tax lien, not the probate fee lien.
Okay. That's it. Thank you, Mr. Chair.
Thank you, Representative.
Further questions or comments from the committee? Further questions or comments? If not, thanks for being with us, Judge.
Thank you. Have a good afternoon or day, morning.
All right, Madam Administrator, I understand Jonathan Scher is not with us.
That's correct. He'll be speaking at the end of the day. And the next person, Chris Erb, if you would let him know he's going to get a prompt. He's gotten prompts that said the host would like to promote you as a panelist. He needs to say join as panelist. He needs to click that button that says join as panelist. Otherwise, he's stuck in the being an attendee instead of a panelist with the rest of the group.
All right, we will give a moment for that. If not, we will skip him and try to do it at the end as well.
Okay, so then he's raising his hand, but it's not going to help us. Alrighty.
All right, well, we will do that.
So we'll move on. The Attorney General's office is not present yet.
Okay.
So
Is Michael Donnelly with us?
it is not so far.
Okay. How about David Slapian?
Nope.
Okay. Heather Summers?
Kate Childs, number 13, is on the list, and she just entered the room.
All right.
The next one that would be available to speak.
Let's do that then. Kate Childs, please.
Hi, good morning.
Good morning.
Thank you for taking the time with me today. I'm here to testify on House Bill 5463. It's regarding price gouging and the Office of the Attorney General to bring action against a seller who engages in price gouging during disaster or emergency. Our family has owned and operated since 1979 a full-service heating oil company, a COD cash-based heating oil company, a full-service propane company, and I have been involved with the family operations for almost 20 years. So I just want to start by saying that we care most about our customers, right? Without customers, we don't have a business. So I imagine that all retailers feel that same way, that the loyalty of their customers is what drives success. So every spring, our company comes out with multiple pricing programs that we offer our customers to protect them, not only from rising prices, but also from market fluctuations down. And they're in the form of things like prepaid contracts or cap pricing, where we lock them in at a certain number that they won't go above, but they are allowed to go below that pricing. From the seller's perspective, this is a very complicated process to secure the oil. We can buy wet barrels, we can buy paper contracts, we can buy put options and call options, and that allows us to do the downside or upside protection as well. And this past season, our customers who did these programs have saved, in this environment, over $2 a gallon on their deliveries of heating oil. So over the course of the season, we may have saved them between $500, $1,000, or even more. However, this past month has proven to be very difficult for everyone in our industries, both customers and the dealers. We've seen huge price changes, but the unique thing about this stretch is that every night we get a price, and we base our delivery the next day on that price that we're expecting to pay for fuel. And when I come in and wake up in the morning at 6 a.m. and I already have all my suppliers telling me, oh, just kidding, you're going to pay 20 cents more when you come pick up the fuel this morning. And then at 8 o'clock, oh, another 20 cents more, and 11 o'clock, another 20 cents more. I've already set these deliveries for the day for these customers. They're at a fixed price, printed on their ticket. And here I am going to pick up their fuel at 60 cents more than what I thought I was going to pay when I went to get the fuel. And then the downside is still has all the same sort of complications associated with it. So it's a very unique market. It's complicated, and it's what we have right now with price gouging is a defined structure with how you determine what your margins were, what your margins are, what did you pay, what were you quoted, and it's a process. This bill basically takes that process out, and it simplifies it. Well, this is what you bought it at, and this is what you sold it at. It's just not that simple. We don't work in real time. We work in future markets that are trading by the minute with huge price swings. And you have to look at our whole process to determine.
Ms. Childs, I should have announced this at the beginning and I didn't. We have a 3-minute time limit for testifying. Like I gave you a little longer, but I guess just drill down for me a little bit, because I hear what you're saying, but I'm trying to figure out how this definition of unconscionably excessive price, I think, builds in, at least the way I read it, builds in, if you look at I think line 16 to 18, builds in the amount charged versus sort of going back above to what it was bought at. So the analysis you're laying out to me, I'm trying to figure out how that is not factored into lines 11 through 18 of the bill.
Well, first of all, there's already language that exists. I'm not sure why we're needing to override that language. It's in Public Act 10-176, I believe. So there is already price gouging language that we adhere to. I bring up the contracts I buy contract fuel to secure those prepay contracts at that low price. What's to say I didn't pick up that contract fuel on that day that I delivered to someone else at a higher price? That you can't just look at one snapshot in time and say, well, you bought it at this and you sold it at Y and you're price gouging. There's a whole company, there's a whole variety of programs that you have to have transparency on what you're doing to determine price gouging. To just say, well, you picked fuel up at this and you sold it at that. It's not realistic in our complicated company. And again, we adhere to the price gouging rules that already exist.
You said 10-176.
I believe that's the number. I'm sorry, I'm not, let me double check. I believe that is correct.
I think it was public. I think it was public Act 10-176, not the statute.
And it provides the new bill doesn't provide a definition of gross disparity either. So we're working with a blank guideline.
Okay.
It gives us no defense as to what we're doing.
All right, Representative Fishman.
Yes, thank you, Mr. Chairman. Hi, Kate. It's an interesting topic because I think the language as presented is very broad, and I don't know that it was meant to capture your industry, but let me just get this straight. So at the beginning, let's say it's summertime, you offer to the general public, you can contract with us to be your person at a certain level of price per gallon. Is that fair to say?
Yes.
And there's an incentive to both sides to engage in that contract. First of all, the homeowner in this particular case knows what they're going to pay with no fluctuation. And you can plan because you know what you're going to need for the season.
Correct.
Okay. So those customers in effect become priority customers because you got a contract, right? Yes, but they're not necessarily treated any different than any other customer. They just have a fixed price when on their ticket. Certainly, but if I called you up and said, you know, I need a delivery of oil, I've never done any business with you before, you've got to either attain that oil or maybe you have it in reserves from some sort of buffer that you ordered at the beginning of some period. Is that fair to say? If you called me for delivery, I would quote you market price that day, like I had no inventory, like I had no, the competitiveness of the market would require me to do that, right? Whatever the market is justifies that day. Sure, and you're not required under some standard to keep the oil for your contract customers separate from the, emergency call customers, correct? I don't even know how you would do that. Okay.
I mean,
so-
it's you blend your truck together to hit all your deliveries along the way. Everybody has a different price on the truck depending on potentially what contract they bought. So the truck is going to go out and be in an economies of scale as they deliver. I choose when to lift the cheaper price based on the market.
Sure. So if you have a contract in August and you order in September and that oil is delivered to you at the end of September, it's probably going to be at a lower rate just naturally than January.
So not quite, because we buy it in the futures market. So if I sell you a contract in July for a fixed price for the winter, I'm buying a little bit of your fuel in September, a little more in October, a little more in November, more in December, more in January, and then it backs off. It's a futures market where I can go out in the future and buy oil at a fixed price. And I do that multiple ways. I do it with wet barrels from my supplier. I do it with paper trading, like you'd see on CNBC on the screen.
Okay. And you mentioned that there's certain protections in place already regarding price gouging that went into place 2010 or so. How does that work now?
Well, I've not had to be subject to any investigation, so I can't speak to it from experience, but it takes a look at your history of your margins and what you're charging now. And I don't know the specifics, but I can tell you that from my business, if the market is trading higher, today's oil in theory is cheaper than tomorrow. So I load and I go to what they call the rack and I pick up the fuel. If today's price and the market, let's say the market's down 20 cents today, which these swings are insane. We've never seen this before. Tomorrow's oil is cheaper than today because the market's down. So when the market closes, tomorrow oil should be cheaper than today. So today I will go and load my fixed price fuel because I don't want to buy that rack fuel today. Tomorrow's cheaper. It's a very complicated business. And my concern is just that we can survive with the language that exists. To give a blanket general description of price gouging when we have a very complicated structure that you'd have to look at the whole piece, all of the pieces, is concerning.
Yeah. All right. I agree. Okay. It's an interesting topic. So thank you, Kate, for coming here today. And thank you, Mr. Chairman, for the opportunity.
Thank you, Representative.
Chairman Winfield.
Thank you. Good morning. Good morning, Ms. House. The question, so, and you may be completely right. I'm just trying to understand the effect of the language before us. And then early on in the bill, in lines 16 through 18, it has a portion that thinks about the cost to the seller, whether it be to sell, to buy, all of the things that you have to do. And you're saying that you don't think that captures enough of what you would need to be not exposed by this piece of legislation should it become law? Is that what you're testifying?
Yeah, who defines those things? There's no descriptive definition in those words, whereas the language that exists now specifies that if you are historically making X, you are still allowed to make that amount. Whereas this language says, well, we'll take all of it into consideration, but we're not really going to define what's allowable and what's not. It just doesn't define what the Attorney General's office is going to determine as gross disparity. It's it leaves us with a huge defense of ourselves that we already have a bill or a act with language that has been the standard for the industry.
Right. And the reason I'm asking is because I don't know after this hearing what happens with this, right? And so I'm just trying to figure out, should this move forward? How is the best way to move forward to make sure that the very things you're talking about that you're wary of don't come into play? And so if we were to move forward with this kind of a structure, you would maybe not feel great, but feel better if we did something about defining those parameters better.
I think that's a fair statement, but again, you already have them. So I'm not really sure why we're trying to take them away in the bill. That's why I'm here to testify.
No, I understand. I'm just seeking to, when the conversations happen, to be able to speak about this in a way that I can't currently speak. Thank you very much for your testimony. I appreciate it.
Thanks, Chair.
Thank you, Senator. And obviously the Attorney General's office is going to testify. So we will certainly get clarity from them on how this matches up or doesn't with the 2010 legislation. So Ms. Childs, thanks for being with us this morning.
Thank you very much.
All right. It looks like we have Chris Herb with us. We've got him admitted here. So let's go back to that, please.
Good morning. My name is Chris Herb. I'm also here to speak on House Bill 5463 concerning price gouging. Our organization, the Connecticut Energy Marketers Association, represents 600 marketers in Connecticut. We employ 13,000 people in our state and provide motor fuels to over 1,000 convenience stores throughout the state. Before I begin, I want to remind the committee that Connecticut is a divorcement state, which means that vertically integrated refiners are prohibited from owning and operating gas stations. The companies that we represent are typically the ones you buy energy products from. They're small, local, family-owned businesses that sell bioheat, heating oil, propane, gasoline. They've been around from 2 to 4 generations. So that's really what this bill would cover, those family businesses. Our testimony today follows this logic. I commute between Naugatuck and Cromwell every day. When on I-91, the posted speed limit is 65 miles an hour. If suddenly the speed limit was set as an unconscionably excessive speed, and it was just left up to the state police to determine if I was speeding or not, that would be unfair because I would not know how fast I could drive without breaking the law. About 10 years ago, we addressed this lack of clarity after previous investigations into alleged gouging, where the law failed to define terms like abnormal market disruption, unconscionably excessive, and gross disparity. We worked with the Office of the Attorney General at that time, Richard Blumenthal, and our esteemed current Attorney General when he was a state representative, along with other members of the General Assembly on gouging legislation that actually does protect consumers and provides guidance to local family-owned businesses about what gouging actually is. Since that time, Public Act 10-176 has allowed the AG to protect consumers and provide clarity to our businesses. Prior to the changes that were made, gasoline retailers in particular were in the dark as to if and when they were gouging. Connecticut law provided no guidance to the industry or to law enforcement officials as to when a gouging occurs. Fortunately, that's no longer the case. It's no longer held up to the eye of the beholder to determine when that's happening. We are concerned that HB 5463 takes a step backwards and believes that what is being proposed is already covered by existing law and does not need to be duplicated. Gouging consumers is unacceptable, but passing a bill that does not seem to precisely define gross disparity makes it impossible for a business to understand how they can price their products when they are accused of charging an unconscionably excessive price, which is unfair to consumers and the businesses that serve them. We ask that language in Public Act 10-174 be used in place of this bill to help businesses know what the rules are when there's an abnormal market disruption and not be left up to the eye of the beholder that's responsible for enforcing the law. Thank you.
Thank you. Representative Fishbein.
Thank you, Mr. Chairman. Good morning, sir. Sir, it's sort of like I have like half of the puzzle pieces. So do you happen to know, 10-176 is the public act, and then that becomes a statute. Do you happen to know what statute number I should be looking at when you say, we've already got laws in place? I want to put those puzzle pieces together. So, and you may not know, we may have to ask the Attorney General's office, but I'm having a little trouble connecting those two.
I will email that to you. I'm just trying to find it quick. I'm not gonna be able to do it with the time that permits, but I'll get that to you.
Yeah, we're gonna ask the Attorney General's office about it. So I just didn't know if you had it handy.
Basically, I think some of the confusion here is there are a number of gouging statutes. Some are like the one that we're currently in is an abnormal market disruption that the Attorney General by law was required to declare when we hit $3 a gallon. That's the statute that we think provides absolute clarity to businesses in the framework in which they can operate. There are other gouging statutes that are typically triggered by the President of the United States or by the governor that says there's a transportation emergency, there's some sort of state of emergency. This bill is trying to change the declared emergency statutes that would allow the Attorney General to have this power to go after people for quote unquote gouging. And what we're saying is that public act, which I'll get you the statute site, language should be integrated into those declared emergency statutes so that business, you know, if the abnormal market disruption provides clarity to businesses, why shouldn't all the gouging statutes provide clarity to businesses?
Well, I understand what you're saying, and it's sort of trust but verify. So if you said to me, you know, it's 4-183 or something like that, which I know it's not, you know, I can look at the two. But anyway, you also mentioned Public Act 174.
I misspoke. It was 176. Sorry.
Okay, no problem. No problem. That's all I had. Thank you, Mr. Chairman.
Thank you. Representative Fishbein, it looks to me like, just for the record, and we'll get clarity from the Attorney General.
42-232.
It looks like 42 dash, looks like Public Act 10-176 is codified at section 42-511 and 42-234.
234. Yep.
234. Section 2 is 234 and section 1 is 42-511.
Thank you very much.
Thank you, Mr. Chairman.
Westlaw to the rescue. All right. Further questions or comments from the committee? Further questions or comments? If not, appreciate you being with us, Mr. Herbert.
Thank you.
All right. Is the Attorney General with us yet? If not, we're going to go to Senator Summers. Senator Summers, you have the floor.
Yes, good morning. Senator Winfield, Representative Staffstrom, and distinguished members of the Judiciary Committee. I'm here in support of SB 434. It is an act concerning the court processes associated with the announcement of a verdict in a criminal proceeding. For weeks last fall and winter, I sat in the gallery of a New London courtroom and heard the details of a brutal triple homicide in Griswold, Connecticut. I sat with the one family member who was left after this triple homicide. I had been to trials before, but this was the first criminal murder that I had attended. It was 100% eye-opening in many ways, a true learning experience, sitting with the victim's family and also seeing the defendant's family and the struggle that they are also going through during this process. My 18th district includes Griswold and the town where these three family members of the Lindquist family were killed in a horrific murder, Kenneth, Janet, and Matthew. And they were killed in 2017. And the jury members in this particular case deliberated for days after about 6 weeks of a trial. And during that time, I learned that many of these family members that were attending or friends of family on both sides, both the victim and the defendant, were taking time off of work unpaid to be there in support of their family member. Most of them had used up their vacation time, personal time. And in this particular case, the victim closest to the family, Eric Lindquist, was a state employee who had used up all his sick time and was attending the trial of his parents and his brother unpaid. After the jury went to deliberate, it took days for them to come back with a verdict. And what I learned is that you never know when the jury's going to come back with a verdict. And many of these people wanted to get back to work and be called when the jury was in with a verdict. And what I learned at this time was that once the verdict's in, it is really up to the judge's discretion as to when he calls the defendant in and the prosecution to read the jury verdict. In this case, the judge gave deference of 20 minutes. Now, both Eric Lindquist and his family live 40 minutes away from the courthouse, and Eric works in Hartford, which is over an hour. So what family members on both sides are forced to do is to sit around in the courthouse and wait, many times unpaid, and many times having to find childcare, etc., why a verdict is deliberated and finalized. I think it's important that we give families in the state of Connecticut some deference and that there is a minimum time in which the judge has to wait before family members can arrive at the courthouse to hear the verdict on both sides, both the victim and the defendant. And this bill would ensure that victims of crimes, as well as family members of defendants, have adequate time to travel to the court to hear the verdict. I was told at this particular time that once a verdict is called, the courtroom doors are shut and you are not allowed to enter. So I also wanted to mention that Eric Lindquist, who is a state employee, whose mother, father, and brother were murdered, is committed to helping improve our justice system, as he has been a firsthand victim and also gone through the judicial system to see some of the tweaks that we could make to improve it for all, both the victims and the defendants. Thank you for this consideration.
Thank you, Senator. Senator Kissel.
Thank you very much, Mr. Chair. Senator Summers, thank you so much for taking the time and for the thoughtfulness in offering this bill proposal. I think it's unique. You bring a perspective that in all my years on this committee, I haven't really realized. We do enshrine our protections for victims and victims' families in our Constitution. The state voted on that. And it strikes me, I don't know what the magic number is, but it does strike me that we should be able to work with folks in the judicial branch to come up with a better, more predictable solution. I can't imagine waiting there for weeks on end and then finding myself outside the courthouse after my parents and brother got killed. And I'm not saying whether, guilt is found or not found, but then racing to the courthouse and finding the doors locked. I can't imagine that. So I think we can do a better job and find a happy medium. And I appreciate the fact that you've brought up the point that this doesn't just benefit the victims, friends, and family, and those that are there in the courthouse on behalf of those that were harmed or murdered or killed in some way, but also the defendant and the supporters of the defendant and their families. So thank you very much, Senator.
Thank you. If I could just say that what I learned was some judges in the state will call the jury in immediately and there's no time to get there, and other judges will give some discretion, and the family advocate, the victim's advocate, has a text stream where she'll try to text people and say, the jury verdict is coming, you got to get back here. And in this particular case, I remember walking into the courtroom and there was a woman who had traveled from Pearl Vision in New London, Waterford, and it's not an easy courthouse to get to. And she was literally running down the hallway to try to get in before the door shut so she could hear the verdict be read. And this is also true for the defendant's family who wants to be supportive. And in this case, the defendant's family was from Hartford, having to get down there in time to meet the time in which the verdict was called was a real struggle. So I appreciate the committee taking this under consideration.
Thank you. Thank you, Mr. Chair.
Thank you, Senator. Let me just ask you on that point, because I certainly understand where this is coming from and the desire for this. But doesn't a judge necessarily need a degree of discretion? Because as much as we talk about the victim's family, certainly, and the defendant's family, a judge also has to consider a jury who really are volunteers and being held at some point. So, I mean, if I'm imagining a situation where you've got a family who's an hour away, the jury reaches a verdict at 4:30, right? Courthouse has to close at 5 because of, collective bargaining issues and the like. I mean, marshals and everybody goes home at 5 o'clock. So if the family is an hour away and it's 4:30, do you allow the verdict to be read at 4:45 or 5:05 in order not to have to call the jury back in the next day?
I thought about that, and what I was told, and I don't know if this is true, is that when a verdict comes in, if it does come in that late, where the court is just about to close, that typically the judges don't like to do that because of that reason. But I wasn't really asking for anything exorbitant. What I was trying to frame was, could they give between 45 minutes and an hour for people to get there? But if everyone is already there and you have an idea of that because the victim's advocate has been working with the families and the defendant, you have an idea what family members are there, then the judge could go ahead and proceed. But at least give people 45 minutes to try to get there to have that verdict be read. I can tell you the courthouse in New London, just to get from the highway to the courthouse takes about 15 minutes. It's just not an easy place to get to. Then you have to park and you have to get inside. And the idea of having to stick around a courtroom when many of them don't have a place where you can eat anything, there's no food allowed. You're going through security, waiting and waiting for weeks on end. Again, unpaid, people have childcare issues. And both the victim's family and the defendant's family, I found, wanted to be there for someone going through this, just to give a little more, humane response to something that's so traumatic, to allow family members to get there. And I wouldn't have even brought this up if I didn't learn that some judges immediately call, the jury in, and others in this case did give a little bit of discretion, but it was like, you have to be there in 15 minutes. So to set a standard so that families have an opportunity to get there to hear the verdict on both sides.
Yeah, like I said, certainly understand where this is coming from. I think we may need to work on the language. Did you have a chance to look at the testimony from the Judicial Branch on this?
I did a little bit, but I need to study it in further detail. I would like us to be able to come to a compromise. And again, I would have not even known about this if I hadn't sat through the trial and learned. And, I saw the defendant's mother struggling to get down there. Sometimes she had to bring her disabled child with her because she didn't have childcare and she didn't know how long she was going to have to be there when the verdict was going to be read. And I don't recall seeing her on the day that the jury came in. Obviously, she had to work. I know she was taking time off from her job also. And, that was unfortunate because I'm sure she would have wanted to be there for her son, who is the defendant.
Sure. Representative Quinn.
Thank you, Mr. Chairman, and thank you, Senator Summers, for your testimony and for bringing this forward. I think I know where you're going with this, and I completely agree with the motivation. But, I think I would have to agree that I think we need a better word than sufficient in here, because it just doesn't, give us a clear idea of what that is. And in many cases, families are at the trial and able to be there for every minute of every second, so it wouldn't necessarily be an issue. But I understand that there are other circumstances like what you have relayed to us. It's just a question of what does sufficient mean, and should we have the victim advocate have much more of a role in this in advising the judge of the availability of victims' families and that sort of thing. Those of us of a certain age can remember the O.J. Simpson trial verdict, which was delayed because of people having to come in, and they actually gave it a specific time. But I mean, we also know that was a made for television event, and not every trial ends up that way. But, that would be my concern, is that I'd like to see something, a better word than sufficient, because I think it just gives too much discretion and may not accomplish what you're trying to do, which is to make sure that victims' families have sufficient time to get there.
I thank you for that. I was thinking, originally 45 minutes to an hour. And I do think that the victim's advocate could have a much greater role, but also for the defendant's family also. If they know that everybody on their text message stream that's been attending wants to be there for the verdict and everyone's there, then they could alert the judge, everyone's here, we're ready to go on both sides. But it is something that it came up continually. And in this particular case, the young man, Eric Lindquist, his whole family had been murdered. So the people that were there were friends or neighbors taking time off from work. He had a couple of friends that were working at DEEP or DOT that would try to schedule their time to come off, and they couldn't be there, which is one of the reasons why I wanted to be there for him. And they didn't have an ability to sit there weeks on end unpaid to be at that. And again, when the jury goes out, you have no idea when they're going to be coming in. And there's also very obviously high emotions on both sides at that particular time, what's going to happen. So if there's any way we could give families on both the defendant and the victim sometimes so they know they can get there, whether it's working more closely, but setting them in at least give them 45 minutes unless the victim's advocate or they say they're good to go on both sides to get to a courthouse. Obviously there's traffic, there's parking, there's this, and if not, they're literally confined to the courtroom area or waiting outside in their car.
Okay. All right, thank you. Yeah, and I would also share the chairman's concerns about the juries themselves. I mean, obviously, they've now given of their time and sat through an entire trial, and in their minds, once we give the verdict, we can get out of here. But I would say in those circumstances that probably the victim's family would rank higher in stature than the juries. But I think we just need to specify this a little bit better, but I completely agree with what you're trying to do here.
Thank you for that.
Representative Fishbein?
Thank you, Mr. Chairman. My perspective, this bill is all about compassion, not just compassion for the victim's family. I mean, to say that it's the victim's family gives the presumption that the person is going to be convicted. But we get people every day in this country that are arrested and they're exonerated after they've had a jury examine the evidence and hear. And I have to tell you, as an individual who's had a couple of family members incarcerated for over decades, it's emotional for the accused family also. So if many of us, I think, have watched the video of Kyle Rittenhouse when he was exonerated and how emotional that was for that young man. I really think that we should be looking at this closely, and I have to offer that not all of these individuals are volunteers, quite frankly. I think we passed a law last year that allows individuals to be paid minimum wage for serving on a jury, and please correct me if I'm wrong. But from there, we do have that issue of juries, and I'm not saying this happens, but the perception that you need to come to a decision so that you can get out of here. That I don't think is necessarily justice. And, I think we have to be very careful if we set a time period, which I would be in preference of the time period instead of collecting and counting heads, because that becomes logistically very difficult. But, you have a jury that comes back at 4:45. What do you do when the statute says you have to wait 45 minutes before you release that? You're not going to, I guess logistically you hold everybody over to the next day. But then, somebody knows there's an answer out there, and that's another sleepless night. So I totally understand and I agree with the underlying thoughts of this bill, and I think we got to look at this very closely. So no questions, just a comment. And thank you, Mr. Chairman.
Thank you. Senator Winfield?
Thank you, Mr. Chair, and I'll just be brief. Good morning, Senator Summers. When I first saw the article about you looking to do this, I thought it was something we definitely should be having a conversation about. So when I saw the proposal amongst the list of proposals, it was great to see that. I do, having read the Judicial Branch's testimony, I do take their commentary very seriously. But I think what you're hearing here is that if there is a way to do it, there's concern about the issue that you're talking about, and that we'll put our heads together and figure out how that's done. And I think that's exactly what the legislature should be doing, right? Making no promises, but very much concerned about the issues that affect people, particularly the families on either side of these issues. It can be the point at which you feel as though you got justice or didn't get justice. That's a very emotional point. It could be the moment where you last see a family member free. That's a very emotional point. And so I just wanted to weigh in to say that we are taking this very seriously and we'll do our due diligence to try to figure out how to make it happen if possible.
I appreciate that very much, Senator. And I just want to clarify the whole chain text thing is what they have to do now to try to get people there. I don't, it's not efficient, you know, the victim's advocate and the defense attorney trying to text people to say, oh, I think the jury's coming in. And I appreciate you being willing to work at it. If there's anything that I can do to help, I'm happy to help. And I am thankful that this committee sees that this is trying to, show compassion on both sides of this issue. And it particularly struck with me that the defendant's mom, I saw her there most of the trial, but again, she was bringing a disabled child with her and she didn't make it on the day that her son was found guilty. And as a mother, that was something that really struck with me. And all I kept hearing, she had to work, she worked. So she probably couldn't get there in time to hear it. And it's something that has really stuck with me. And I'm hoping that we can work on this so that both families of defendants, of victims have an opportunity to be there at this very emotional and crucial, probably one of the most crucial moments of their lifetimes. So I appreciate that. Thank you.
Thank you. Senator Kissel.
Thank you very much, Mr. Chair, for the second time. I haven't spoken to my colleagues, the co-chairs and Representative Fishbein, but Senator Summers, I would just, while I have you here, I would recommend that you have your aide reach out to the liaison or folks from the Judicial Branch. And why don't you guys just set up a meeting and see if you can't come up with any kind of language or anything like that. I only say that because Senator Winfield made it very clear we're all very concerned about this. But I will tell you that the members of this committee, our plates are full until our JF deadline. We're now like requesting going in on Tuesdays and Thursdays. And just as a practical matter, if you can get us even part of the way there, that's going to be a big help. So I just think that since this is your proposal, Senator Summers, I think it would be really helpful if you really looked at the Judicial Branch's testimony and try to sit down with them and see if there's any kind of ideas you guys can come up with to get us further down the road on this issue. And I hope I'm not speaking out of turn, Mr. Chair, but I just think that would be helpful.
No, you're not at all, Senator Kissel. I was actually just going to raise the same point because obviously, we have a JF deadline coming up April 4th. We would certainly like revised language well before then if we can. So we're running out of time.
I will be happy to work on that and try to get you something as soon as possible.
Yep. And the other thing I will just mention on that point is obviously this is one of those bills. This happens a lot in this committee. It's the type of thing that could be statute, but really probably should be a judicial branch rule change as opposed to in statute. So you may be able to work with them on proposed language for a rule to obviate the need for a statute as well. So talk to them and get back to us.
Okay, take care. Bye-bye. Thank you.
All right, we are going to move on to the Attorney General, William Tong.
Thank you, Mr. Chairman. Great to see you, Chairman Staffstrom, Ranking Member Fishbein, Chairman Winfield, Senator Kissel, Ranking Member Kissel. It's great to see you all and to be home in the Judiciary Committee. Thank you for the opportunity to testify on a few bills this morning. I'll try to keep it brief because I know you have a full agenda. So the first bill is House Bill 5463, and the Office of the Attorney General strongly encourages this committee to update and strengthen our state's price gouging laws. So during this 2-year plus pandemic, I think all of us, particularly all of you, have learned more about price gouging than you ever wanted to know. Unfortunately, it has happened quite a bit since the onset of the pandemic, and we've received more than 750 individual price gouging complaints in my office. It's probably much bigger than that if you add all the complaints that go to DCP and all of you and your offices. And we run down and investigate every single complaint. And what we have found is that very often we talk to a local retailer, store owner, mom and pop shop, and they have a good explanation as to why the price went up for hand sanitizer or masks or eggs or a gallon of milk. And what we're finding is that usually an invoice shows that they're getting charged a much higher price by their supplier, wholesaler, distributor, or manufacturer. And under our current law, 42-232, we don't have the ability, the Office of the Attorney General does not have the ability to go up the chain in the stream of commerce to go after the supplier or the wholesaler or distributor or manufacturer. That's a huge enforcement gap in our law. It actually manifested itself in investigation around egg prices. For those of you who may remember and need a lot of eggs in the house, egg prices spiked early in the pandemic. There was a multi-state investigation. It appears that New York and Minnesota, for example, because they have a broad price gouging law, were able to take action against a mega egg producer. This is an egg producer that has a subsidiary here in Connecticut, but we were unable to take action against the producer and to go up the chain because of the limitations of our law. Also, our law has a fairly unworkable legal standard where it asks us to assess whether the price exceeds the price in the ordinary course of business. That's been abandoned by most states in favor of an unconscionability standard, whether the price is unconscionable. We use that standard in a sister statute, 42-234. And so I urge that you adopt that standard here. This bill passed the General Law Committee last year. I think it was referred to this committee, and it passed the House and not the Senate. So I encourage you to take action on this year. It is incredibly important to the residents of the state who every day, it seems, call our office with a complaint about potential price gouging.
Mr.
Yes,
Chairman.
Mr. Chairman.
All right, so couple things. One, I know there's a bunch of folks from your office signed up. Are they individually testifying, or are they just here to answer?
They're here to add support when the Attorney General is out over his skis.
That's what I figured. All right, just wanted to make sure. So we will get.
I will call them if we need them, if that's okay, Mr. Chairman.
Yeah, no, as long as I see you brought a deep bench, so that's good, because as somebody who cleaned up your messes for long enough, I know exactly
yeah, I think the chairs and rankings will say that you were not the only one who cleaned up my messes.
So I hear your point about going up the chain, but we've already heard from a couple folks, and looking at my list, I've got a whole bunch of folks who own oil companies who are not up the chain, but are point of sale folks ready to testify today to say, no, that's not what this bill does. So you want to address that head on for me?
Well, I'm not sure exactly what their concern is. Let me just clarify one thing that I think is not well understood. We are seeking to amend the general price gouging statute 42-232, which only kicks in after the declaration of an emergency. So we've all become more familiar with emergency powers than we ever wanted to know. The one that we are most familiar with is a civil preparedness emergency under 28-9. There are other emergencies that can trigger this statute, but this statute only applies upon the declaration of an emergency. The other thing I want to clarify is
so on that point, let me make sure I understand this, because I don't want to go round and round on this. So we've been hearing about Public Act 10-176. So is it your testimony that House Bill 5463 will leave Public Act 10-176, which I think has been codified at 42-511, unchanged?
Yes, I believe if I'm the Public Act in statutory citations, I believe that Public Act 10-176 was codified as 42-234, if I'm not mistaken.
I think part of it's there.
Okay.
Or it's 234.
So let me just clarify. 230. Let's just say that wherever it is in the statutes, this is a separate statute that you're talking about right now. That relates to energy commodities, basically. And that statute, gasoline, home heating oil, other energy fuels and sources, that statute only kicks in when we have an abnormal market disruption, when the Commissioner of Deep and the Attorney General together declare an abnormal market disruption. We have one right now. I don't think I have to tell anybody that we have an abnormal market disruption in gasoline prices, but Commissioner Dykes had to declare that. I had to do the same, and that's when those powers and authorities kick in. It is a different statute. Interestingly, though, in this statute, in 10-176, the energy price gouging statute, we use the unconscionability statute in this statute, and we can go up the chain in this statute. But again, both of these statutes only apply in certain circumstances once there's a triggering event. And so I think the confusion is conflating the two statutes, right, as being one and the same. They are not one and the same. And then not understanding that one is triggered by a gubernatorial declaration of an emergency, and another is triggered by an abnormal market disruption, which is declared by the Commissioner of Deep and by me.
Understood. Okay. I know you've got other bills you want to talk about, which I'm going to let you get to briefly in a minute. I just want to see if there are any questions from the committee on 5463 before we move on, just to kind of keep this easy. Senator Kissel, followed by Representative Fishbein.
Thank you very much, Mr. Chair. And I just want to say that was like, it made me feel young, because watching that discussion was like back in the days when the chair was talking to the vice chair during screening.
When we were actually young.
We're all young. Although it seems like just yesterday, Mr. Attorney General, I was urging you to take Sasha to see the Lego Batman movie. And where does the time go?
Where is it?
Yeah, just two quick questions on this particular point. The first one is, you said a gubernatorial declaration of emergency. What if the legislature declares an emergency? Would it still?
If it is an emergency under the same title, then yes, it would apply.
Okay, and just generally, how would you specifically address this issue that the analogy was, you drive down the highway, the speed limit is 65, people sort of know if they're going past the speed limit, whereas a different, more subjective standard doesn't offer the retailers enough guidance to determine, especially in a very volatile environment for fuel such as we're experiencing right now. In other words, as Chairman Staffstrom said, we have a lot of people signed up with concerns regarding this, and I want to reassure them that there is some kind of bright line that would offer them guidance so that they don't run afoul of Connecticut law.
Well, thank you for that question. Number one, unconscionability is a standard that we learn about in the very early days of law school, and it's something that courts have addressed. There's tons of case law, have wrestled with for a very long time. So it's not a new standard. It's not an unknown or uncommon standard. And so lawyers and judges and legislators have a lot of experience with this standard. Secondly, we use standards like this that aren't numerical standards or mathematical formulas, but they're legal standards in the law all the time. So, for example, beyond a reasonable doubt, preponderance of the evidence, clear and convincing, right? Abuse of discretion. These are all legal standards that we on this committee and as lawyers and judges and a legal system understand what they mean. They mean different things in different circumstances based on different facts, but we have no trouble applying these standards because that's the task of the law. The trouble with a numerical standard is that it can be a roadmap for evasion. Other states have struggled with that. You know, they've tried to say, well, if it goes up more than 15%, or if it goes up more than 20%, then that's price gouging. And anything other than that is not price gouging. The trouble with that is, let's say it's 20%, then that gives the potential price gouger a roadmap to say, okay, I'm at 19.2%, so I'm good. I haven't hit 20%. The problem with that, of course, is 19.2 is plenty close to 20 and probably is price gouging in that circumstance. So I guess what I would say to people is that this is nothing new in the administration of the law and in a fair system.
Well, Attorney General, I thank you for that. I look back fondly to our times where I was one of the tri-chairs with you on this committee. I can tell you that you just have a fabulous staff. They're very helpful and informative. Kara in particular reached out to me on a different matter. And you have suffered through my bad jokes for so many years. And to make
and
a good
too.
so I'm going to throw in, I can hear you. And to make a good omelet, you do have to crack a few eggs. So I'm very sympathetic to you wanting to get up that literal food chain to make sure that the wholesalers and the people even behind them are not gouging people. So I think that's a very valid point. And I will do what I can as the ranking senator to try to make sure that you are not encumbered, but at the same time, the folks that are being regulated or maybe inspected or investigated don't feel that it's an unfair system where they can't really figure out how to work their way through it. Because I think their lifeblood are their customers, and they're going to, most 99.9% of them are going to try to do the right thing if at all possible. So thank you for all you do for the people of the state of Connecticut, and it's great seeing you here this morning. Thank you, Mr. Chair.
Thank you. Representative Fishman.
Good morning, Attorney General. How are you?
Good morning.
You talked about eggs and we talked about petroleum, and I'm just trying to figure out, is it possible just to, since we already have statutes addressing concerns in pricing of petroleum products, to exempt from 42-230 the petroleum industry?
I suppose it would be possible for the committee to do that. I'm not sure I would see a reason to do that, particularly right now when people are feeling so much pain at the pump, even though we have declared an abnormal market disruption. I suppose there could be a circumstance where for some reason we can't declare, or someone is unwilling to declare an abnormal market disruption, and yet we have evidence of price gouging. I don't think you would want to limit the ability of the Attorney General's office to protect your constituents and residents across the state from potential price gouging. Let me also add, if I may, Representative Fishbein, that people have raised concerns about how this might be enforced. Let me just say that we have more than 750 complaints, and many people have been investigated over the last couple of years, many more than I think ever in such a short period of time. And I haven't heard, and I would very much want to hear if anybody feels they have been mistreated or if we have overstepped in our investigations of people. We have found by and large that local retailers and mom and pop stores have not been engaging in price gouging, but that they have been abused potentially by their suppliers, wholesalers, distributors, manufacturers, and that we need to hold them accountable. And they're frustrated that we can't.
So were you here for the testimony at the beginning, particularly Ms. Childs?
I was not. I'm sorry. I was late this morning because I had to take my kids to the dentist.
Okay. And, you know, she described a situation at her particular company where they engage in contracts, you know, pre-season with a homeowner, let's say, for oil at a reduced rate, so that they can plan their season the homeowner has assurances that they're going to have a certain price. That oil is ordered based upon those contracts, but then it's like months later, and the price has gone up, and a homeowner calls. All of the oil is mixed together. It all came in at different prices. How does the AG's office determine the cost and the incidental costs and all of that stuff for the purposes of determining possible violation here?
I mean, this is why we conduct an investigation, and we do a searching analysis of costs, documented costs, by the way, invoices, cost history, purchasing history, who they're buying from, what they're being charged. I think in the situation, and many of us enter into contracts, for example, for home heating oil or other commodities in order to make our lives more predictable and to lock in a good rate. And no one's saying we should change that. I think if somebody's locked in a good rate, there are good arguments that they're bound by contract. I guess there could be a situation where somebody's being charged an unconscionable price at the time they locked in. That would seem to be rare to me. So I don't want to say it's impossible, but in general terms, you would think when somebody locks in at a particular price based on the circumstances at that time, they're making a judgment about what's happening in the world, about where they think prices might go, and they're probably getting a competitive rate at that time. If the world should change 6 months later, 8 months later, I would think that for the home heating oil supplier, it would be an important fact, if not a defense, that this constituent bought at a certain time. They did it with full disclosure, with eyes wide open. This is a matter of contract, and that's a different situation than gouging somebody at a spot price in a particular moment at a price that is so far above what anybody should reasonably have to pay that it is unconscionable.
So Ms. Childs testified this morning that she'll call a supplier at in the morning.
Yep.
And you get one price, and at noon another price, and 3 o'clock in the afternoon another price.
Sure.
It seems like a lot to unpack, but
that's what we do every day.
Sure. What's the definition of gross disparity in 5463?
In 54-234, are you saying
234? I'm looking at the language you've come here to testify in support of, HB 5463. And in particular, lines 11 and 12 make reference.
Let me pull that up. Let me pull that up. I don't believe that the term gross disparity, looking at the language, is defined in the statute, but I think a gross disparity is fairly obvious on its terms, that it represents something significantly different in degree. And so it is a gross disparity or differential between prices.
So who determines what the gross disparity is? Is it that particular investigator?
Well,
could differ from every other investigator in your office?
As you know, Representative Fishbein, we make judgments all the time in law enforcement about whether somebody and their conduct meets a particular standard of misconduct. And then it is on us in law enforcement to put on evidence and make our case that we meet that legal standard. And then it's up to a judge or jury to decide whether we're right or not and whether we've carried our burden. Lawyers do that every single day.
However, in those cases that you reference, which are criminal cases, we do have a legal standard. And that's known as probable cause. But
with
respect,
gentlemen, both of you know this. One person's got to ask a question.
I got you.
Answer it.
Mr. Ranking Member, I apologize for interrupting.
We have the probable cause standard in both civil as well as criminal cases. You can't just go to court. You can't just PJR somebody's home without proving a level of evidence that's actually cognizable. It isn't merely a complaint that initiates. So I'm having trouble with that very subjective, undefined term, opening up the AG's office to show me your books, show me all your papers, you know, how did this oil get into the tank? Where are all the invoices? And, you know, do you have any proposed language for gross disparity?
I think that in lines 11 and 12, there's a fair bit of language and description as to what an unconscionably excessive price means. I would point out that the statute, which is already the law of this state, has another standard that references prices in the ordinary course of business. That is also a standard subject to interpretation and application by law enforcement and by courts. I would say also that threshold standards for beginning an investigation or commencing a law enforcement action are not always number one probable cause, and they're not limited to the criminal context. We have thresholds that we have to meet. We have to. We only start investigations and bring cases if we have a good faith basis to move forward. If there is a standard for the commencement of an investigation or a standard of proof that we have to meet at various stages of an investigation or prosecution, we will meet them. But they exist both in the criminal law and in the civil context. This is what the Attorney General's office does every single day. Let me also say that this is exactly what our constituents want us to do right now. The largest volume of complaints that we get every single day are about allegations of price gouging. People are very concerned that they are not just getting killed at the pumps, but in stores, in grocery stores, and on the prices of all things that they need for their families and for life. And I think they would be surprised to know that the Office of the Attorney General is so limited in its ability to enforce its price gouging, the state's price gouging laws, and that I think they'd be surprised to know that we don't already have the ability to go up the chain to suppliers, wholesalers, distributors, and I would hazard a guess that our constituents would want us to have the full panoply of authority to protect them from price gouging.
In going up the chain, that would extend to businesses, potentially businesses and entities that are outside of the state of Connecticut.
Yes.
So what and I'm just, you know, what happens when, let's just say, we empower the AG's office to inquire of a driller, you know, somewhere in Alaska, and Alaska says no.
Well, I'm not sure what basis Alaska would have to say no if I have proper long-arm jurisdiction or I have somehow personal jurisdiction over the person or business in Alaska. The sovereign state of Connecticut has every right to conduct an investigation and commence an enforcement proceeding. It is the same power that I have exercised to hold the three major drug distributors accountable in the opioid and addiction crisis. It is the same basis of my jurisdiction to go after Juul for starting the youth vaping crisis. It's the same jurisdiction I have to go over Navient or Facebook or Meta or Instagram. They're in many other places in this country.
So what if Alaska passed a law that says you can't do this? You have to show some level of probable cause, your investigator arbitrarily deciding that there's a gross disparity is not enough. How do we face that issue?
I suspect that would run into very serious constitutional law questions, on the order of, now you're really challenging me, International Shoe and Volkswagen and all of those personal jurisdiction cases that give me a little PTSD from civil procedure.
Yeah, the tire case, right?
Yeah.
You just made me flash back to the tire case.
Maybe behind you in one of those books over there.
Yeah. Yeah, I mean, they're all interesting questions, but here, I think in that case, there was an injury or harm that was cognizable. And yeah, the long arm was stream of commerce and that kind of stuff. And I think that was federal jurisdiction, essentially. Wasn't that federal civil procedure? Not that we need to, yeah, okay.
Many of those cases also have a state law analog.
Gentlemen, I'm sure this will be very entertaining conversation over cocktail one night, but can we move along now, Representative?
Yeah, I'm just trying to figure out.
2 cocktails.
Just trying to figure out why we need this. I understand the egg situation. I'm just looking at what we already have in 42.234, which sets a standard. It appears that 42.511 is what do we do when there's a determination that there may have been a violation of the standard, and why we would have both with this very subjective language. So
if I may, I think practically what's happening right now is because of the way that the law works and is written now, practically what happens now is only small business owners in Connecticut are exposed. And the only people that bear the brunt of any investigation are our neighbors and people who live in our communities who run small businesses, shops here in Connecticut. And what is totally unfair is that the law focuses only on them and not the suppliers, wholesalers, distributors who are abusing them. And I say this often, small businesses are also consumers. And when we do consumer protection work, we have to represent and protect small businesses too, when they, as consumers, are gouged by their suppliers, wholesalers, or distributors. And that's what this gives us the authority to do.
So I guess the fear is that if we empower the Attorney General's office with this subjective test to go up the chain to everyone, that those outside the state say, I'm not going to do business in the state of Connecticut because I may fall within this, which is going to lower the supply and increase prices based upon that. So, and I know the legislature has passed many laws that I think give that message, but that's part of my analysis. So thank you, Mr. Chairman.
Thank you.
Representative Fiorello.
Thank you, Mr. Chair. Nice to see you, Attorney General.
Nice to see you, Representative.
So I just reading through this bill, I had a question, which is, it doesn't really specify what products you would have power to, stop the price gouging. And I was wondering, are there any parameters in your mind on what products, or is it really open to any kind of product?
Any product. That's the way the law works now.
Okay. I'm sure you've considered this also, but pricing is nothing more than a market signal, and it's a really valid market signal, and government can't create signals for all the products that are out there. And I think especially, as this bill says, during a disaster and an emergency, the pricing signal is so valuable, because when like water bottles go from $1 to $5 or $10, that serves to help exactly who you're saying you're trying to help, which are the victims of people who are in need during a disaster. And if water goes to $5 or $10, it means that people will not take more than they need. And it preserves these products in the emergencies. And I was wondering, how are you as the Attorney General, and you just said that your office is limited in what it can do. I understand people calling you during an emergency and wanting you to do something because nobody likes to pay higher prices, but there's such a valid function in the pricing signal in emergencies and disasters. How will you be able to do what the market does, which is preserve these scarce products during a disaster and emergency?
So I don't think that pricing is only a market signal. I think most people would agree, unfortunately, that there are bad actors out there. And though pricing does reflect supply and demand and market forces, there are extraordinary moments when people will seek to take advantage of others. I'm sorry to report to this committee that happens all the time. And we deal not just with price gouging, but with scammers. And on a large scale, as you may know, Representative, I'm leading the national generic drug price fixing case. The generic drug manufacturers clearly, brazenly fixed the prices on 90% of our medicine because they wanted to charge us more. That's a form of price gouging. And so during an emergency, that's exactly the moment when we don't want to let somebody charge so much more for water or gasoline or eggs or heat when people are literally dying, suffering, sick, unable to do basic things to care for themselves. If, for example, there's a run on banks and people don't have access to cash, in a really dire situation, that's when you need your Attorney General to step in and say, this is not okay. You cannot take advantage of your customers and your neighbors, and you cannot make them pay more and profiteer off of them because they will pay it. And I'm sorry to say that happens, but it does.
I certainly agree that, there are those among us who indulge in doing evil things. And I think your work is important to go after, people who take advantage of the elderly, for example. But truly, the way this bill is written, I do feel that as well-intentioned as it is, there is a very serious unintended consequence, which is that there's a reason why prices go up in an emergency. And I don't think your office is going to be able to tell who are the greedy bastards versus who really are trying to preserve for their own customers. Because what can happen, whether it's bottles or toilet paper or bread, is you can't imagine that a local grocery store owner would not want, the first guy in the door to be like, great, bread is still $1.50. I'm taking like 50 loaves. And I know you can limit the amount that people can take, but truly the price signal also tells other makers that there is a huge demand, particularly for toilet paper or, whatever. But it's very hard for government actors to truly understand what is happening and that organic feel of what people are in need of, especially during disasters and emergencies. And I just would urge you to, understand that there is a valid role for the market pricing mechanism to be allowed to work. And then you have your own role to truly go after bad actors. But that's all I wanted to say on this bill. Thank you, Attorney General.
If I may, Representative, I guess I would just say, if I can't determine who the greedy bastards are and who we should go after, then who will do it?
I'm saying I think you have a role to do that, but we also should recognize that there's a very valid role for a market pricing mechanism to work, especially during disasters, because they do have the natural pressure to preserve those things that are in scarcity and also to signal to makers to make more of the thing that the prices are going up on. But anyways, thank you so much, and thank you, Mr. Chair. Great to see you, Attorney.
Thank you. Nice to see you. Thank you.
Representative Doucette.
Thank you, Mr. Chair. Real quick, thank you, Mr. AG, for your testimony. Good to see you.
Good to see you.
Wanted to follow up on some of the earlier testimony. I know you said you didn't hear, but you had some interesting testimony earlier, and Rip Fishbein was talking a little bit about it. But there were some good points raised about sort of the vagaries, especially of the oil market and oil futures that we're seeing right now.
Yep.
And Rep. Fishbein, alluded to the example of different contracts bought at different times. So I just wonder if there is some way, and you don't have the answer, at the top of your head, but to account for the vagaries of something like the oil market, which is very volatile. And maybe one thought that occurred to me is, I don't know if there's any precedent for this in other states, but maybe even like a safe harbor sort of provision right in here, which, would, again, account for vagaries of a highly volatile market, like the oil market or something like that. Just a thought idea. I don't know, again, not off the top of your head, but if there's any thoughts you might have on that.
Well, thank you. I guess what I would also say, though, is first of all, it only applies in an emergency, right? So it applies in limited circumstances. The second thing I would say is we have not just the Office of the Attorney General, but DEEP and also the Department of Consumer Protection. There are significant substantive, expert, and law enforcement resources that are brought to bear whenever this statute is triggered. And we don't just willy-nilly go out and say, hey, that price is high, they're price gouging. I've been very clear in my public comments that not every price increase is price gouging, right? I mean, people think that every 5-cent increase is price gouging, and more often than not, it's probably not price gouging. It's probably, as Representative Fiorello said, a move based on the market, right? And the market's responding. It is when we see something unconscionable that we step in, and then we have to test it, because ultimately, if I don't have a good case and I can't prove it, right, I'm going to have to then, maybe come back and say, hey guys, I got to pay attorney's fees because I got that totally wrong. And I don't want to be in that position either. So I'm, the built-in limiter is I'm only going to bring good cases that I can prove. And we bring a ton of resources to making sure that we're right. And if we're not, we'll lose.
No, I appreciate that. And I certainly agree with you. And I don't envision a scenario which, we see your office descending on every, mom and pop oil company. But it's an interesting, and again, in particular to the oil contracts, which is a very complicated market that I do not pretend to understand. Just something that's interesting maybe to highlight in looking at the language of this and the way that this would play out. But I appreciate your comments, and good to see you. Thank you, Mr. Chair.
Thank you.
Further questions or comments on this bill? If not, Mr. Chairman, I just want to say I think it's important you brought this to us. I think we should look at the language a little bit moving forward, but I was struck by your comment that if not looking at the issue of price gouging in an emergency, what is the role of government, right? That is a fundamental role that we play. Certainly, maybe someone can afford $10 for a bottle of water in an emergency, but I know a lot of my constituents cannot.
Right.
That may discourage some, but when you're working paycheck to paycheck. So anyway, you had another bill I think you wanted to just real briefly touch on, because we do want to move along here, but I think you had one other bill you wanted to.
Yes, if I may, Mr. Chairman, I'm also testifying in support of Senate Bill 426, which would be to expand our state's False Claims Act. Like many residents, Connecticut residents, I'm concerned about fraud and misconduct with respect to the state's CARES Act funds in West Haven. I don't have to tell anybody here, there's an ongoing investigation of several projects, including school construction projects and the state pier project in New London. And right now, under our state's laws, we have a very limited False Claims Act. And there's a federal False Claims Act that enables the federal government to go after private actors who overbill, abuse, defraud the federal government. Every single one of our sister states has a similar and very broad false claims law. Connecticut is an outlier. Under Attorney General Blumenthal, we created a False Claims Act for Medicaid only. And we do that work every single day. If you see some announcements that we make just this week, several prosecutions and settlements related to healthcare providers who defraud and overbill the Medicaid program administered by the state. When I was on this committee, many of you may remember, we expanded to include state administered health and human services programs, but we stopped there. And so our state's false claims law only covers about 9 state agencies. There are more than 100 state agencies that contract with private actors. And the fact that we can't, in the Office of the Attorney General, go after bad actors who seek to defraud DAS, for example, and other state agencies, DOT, I think is at best woefully behind the times, terribly out of step with our neighbors, and really inhibits our ability to address corruption in that state. With respect, I think it's a no-brainer that we expand our state's false claims laws to make sure that we're on par with the federal government and our sister states, and I encourage you to pass it.
Fishman?
Yes, thank you, Mr. Chairman. I just a brief question on the price gouging bill. How is an innocent business supposed to recoup their losses for a claim, a wrongful claim? You know, they're exonerated and they've had to hire, you know, some sort of expert to analyze their books, to present evidence to you. Are we suggesting that the state would recoup those businesses, those losses? Okay.
No, this is a question asked by every civil and criminal defendant in the state every single day, whether they will get money back for a law enforcement action being taken against them. In general terms, the answer is no. If we have a good faith basis for commencing a law enforcement action, I have a duty to do that. And I think everybody in this committee wants me to do that. If I do so wrongfully, which I hope I don't do, but if I do, there may be remedies for somebody who's been wrongfully targeted. There are statutory remedies. There may even be some constitutional remedies, but generally, no, they don't get their money back.
Okay. All right, thank you. Thank you, Mr.
Thank you.
All right, anything further from the Representative Blumenthal?
Sorry for the late hand raised. Thank you, Mr. Chairman, and nice to see you, Mr. Attorney General.
Representative, my representative.
I just had a brief question on the False Claims Act bill, which is this broader or narrower than the federal False Claims Act?
No, it is not broader.
Okay. You know, I just in general, I think that this is a great and timely and necessary idea. The Federal False Claims Act has recovered trillions of dollars in fraudulent claims where the government has been defrauded. And I think you're absolutely right that it's a really important anti-fraud measure and that we should have the ability to go after it here in Connecticut to the full extent as well, without regard to the subject matter of the claim. So I appreciate you bringing it to us. And I hope that everyone will support it.
This is another one, Representative, where, like the price gouging statute, I think if you ask people on the street and told them I didn't already have this authority, they would say, you're kidding me.
I guess, sorry, one more question. I know it isn't in this bill, but the federal version of the False Claims Act has essentially kind of a provision that allows private individuals who have information regarding a false claim to recoup some part of the recovered funds if they bring that false claim to the authorities to prosecute it. And I don't believe it's in our state statute, and I don't believe you're seeking it at this point. But if at some point we were to consider that in the future, adding that sort of provision, would that be something you'd support?
That person is called a relator. And I guess I would ask Kara or Greg O'Connell if they wanted to add to that.
Just before you guys speak, if you could just identify yourself for the record.
Greg, your camera is a little funky there. Greg is chief of our government fraud unit in the Office of the Attorney General.
Good morning. To answer the question, our state False Claims Act does have provisions for relators that are virtually identical to the federal False Claims Act.
All right. Well, thank you for educating me, and glad to hear it. Thank you, Mr. Attorney General, and thank you, Mr. Chair.
Thank you, Representative.
Thank you. All right. Anything further for or from the Attorney General's office? If not, thank you all for being with us.
Thank you. Thank you so much. See you all soon.
All right. Next, I have Michael Donnelly.
Good morning, Senator Winfield, Senator Kissel, Representative Staffstrom, Representative Fishbein, and the members of the committee. I am Michael Donnelly, and I am testifying this morning on behalf of the Construction Law Section of the Connecticut Bar Association. The Construction Law Section of the CBA is opposed to the adoption of Senate Bill 426, which would broaden the current state false claim statute, which is Section 4-274 of the Connecticut General Statutes, and is currently limited to the healthcare and human services programs. The proposed legislation would remove that limitation, and from our perspective, would expose participants in the construction marketplace to significant civil penalties, the potential for treble damages, and the possibility of being forced to pay the costs of the state's investigation. We do understand that occasionally high-profile public works constructions disputes can generate substantial negative publicity for the state and other stakeholders. But these are infrequent situations, and they provide a distorted view of the state contracting overall, in that they suggest that there are widespread problems in state contracting that in reality simply don't exist. The simple fact is that virtually all of the construction contractors doing business with the state are hardworking, diligent, honest, productive employers and taxpayers within the state. The significant penalties and cost shifting provisions of the proposed False Claims Act, as well as the ease with which it can be abused by state officials and the relators that were just discussed, would empower the state to engage in a search and destroy mission to unearth financial improprieties that are non-existent, inadvertent, or the result of simple misunderstandings. In other words, from our perspective, the proposed bill is a solution that is looking for a problem. I direct you to the comments of the CCIA, which there's written testimony and they will be speaking later, for a history of the abuse of false claim acts throughout the country. And based on this history, the construction law section believes that the proposed legislation will have the very real potential to penalize good contractors. And its adoption will likely discourage responsible Connecticut contractors from participating in state contracts, which will limit the number of people bidding and increase costs and lower quality. As a result, the section opposes its adoption.
Thank you. Questions or comments from the committee? Representative Blumenthal.
Thank you, Mr. Chair, and thank you for your testimony, Mr. Donnelly. I just had, I think, two questions. The first is, I think you probably just heard the Attorney General testifying that the Connecticut False Claims Act, even with these potential new provisions, would not be any broader than the Federal False Claims Act, and also that other states have False Claims Act that are similar to the Federal False Claims Act and the False Claims Act that this bill would create in Connecticut. And I would ask, do you disagree with those statements?
No.
Okay, and so I guess my question would be, if these laws exist in other states and at the federal level, why hasn't the sky fallen in those other states or around the country in general? And why would that create such a problem here in Connecticut?
Well, I think it has increased costs elsewhere, and there is a long history of abuse. And again, I direct you to the CCIA's more detailed comments with respect to that. It's not going to stop construction, but it's going to increase the costs.
And is your testimony today, it's focused, it sounds like, pretty narrowly on the construction industry?
Yes, my testimony is focused on construction.
Okay. All right. Thank you, Mr. Donnelly. I appreciate it. And thank you, Mr. Chair.
Welcome.
Further questions or comments from the committee? If not, thanks for being with us.
Thank you very much.
All right. We will go to David Slepian, followed by Don Schubert.
Good morning, and thank you, Senator Winfield, Senator Kissel, Representative Staffstrom, Representative Fishbein, and distinguished members of the Judiciary Committee for the opportunity to testify today. My name is David Craig Slepian, and I'm a member of the Executive Committee of the Connecticut Bar Association, the State and Probate Section. I'm testifying today on behalf of the section and the CBA, which is an organization of approximately 10,000 legal professionals, to request your support of Raised Bill number 424, an act concerning real estate in the probate courts. We believe this bill should become law because it's an important and much needed mechanism to address title issues for real property, subject to a lien for probate court fees and a lien for estate taxes. The estate tax lien and the probate fee lien attach to all real property located in Connecticut that is owned by a decedent. The liens attach to the property simply because of the individual's death, not because of an amount that might even be owed. The liens are not recorded on the land records, so can often be inadvertently overlooked when there is a transfer of property. The liens apply to all estates, regardless of size. Therefore, an estate that doesn't owe any estate tax will still need to clear the estate tax lien. The current statutory regime envisions that the liens are cleared in the ordinary course of estate administration. However, it is not uncommon for property that passes outside of the probate process to have these liens exist decades later because they went unnoticed. For example, non-probate transfers that give rise to this issue include transfers that occur through rights of survivorship, which is very common in the case of married individuals, where one dies and the other never probates the estate because there's no actual probate process required, but an estate tax return is, or through reversionary interests. These unrecorded liens go unnoticed until a party goes to sell or mortgage the real property and a title searcher comes upon them from a deceased individual's custody in the chain of title. Once these liens are discovered, it creates title issues that are difficult to resolve under current law. Right now, the owner of the property, who might have no relationship with the deceased former owner whose death created the lien, often must expend a considerable amount of time and money to prepare and file the paperwork needed to obtain the release of liens. The only process available currently is to file an estate tax return with the probate court, or if it's a taxable estate, of course, with the Department of Revenue Services. Raised Bill 424 creates separate mechanisms to release each of the estate tax lien and the probate fee lien. The legislation is limited and targeted, as its only change to Connecticut law is to provide a practical way to release these two liens that have caused title problems for years while still protecting the state's interest. Section 3 of Raise Bill 424 has to do with the estate tax lien.
Mr. Slepian, we're at the 3-minute mark, so I just need you to summarize.
Okay, very good. Thank you for pointing that out. So the estate tax lien, what we're proposing in this bill, and the DRS is on board as well, and I believe they testified earlier today, will automatically release the estate tax lien 10 years after the decedent dies. The probate fee.
All right, thank you. Yeah, I think we have their testimony. Just
right, and probate court administrator earlier testified in support of removing the probate court fee lien by this more practical, streamlined process that still maintains control with the court.
All right, are there questions or comments from Mr. Slepian? Questions or comments from the committee? Seeing none, appreciate you being with us this morning.
Thank you for your time.
All right, next up is going to be Don Schubert, and I am going to pass the gavel to Senator Winfield.
Mr. Schubert, you may testify.
Thank you, Senator Winfield. Good morning, chairs, members of the committee. My name is Don Schubert, and I'm the president of the Connecticut Construction Industry Association. I've known Attorney General for many, many years, and I really appreciate my working relationship with him. And I heard his comments, and I can basically understand his thinking when it comes to a state False Claims Act. But our concerns are basically when it comes to construction, you know, a False Claims Act has very broad legal interpretations. It has very low standards of proof. It has extremely high penalties and damages. And we're very concerned about the potential misuse of a False Claims Act. And in many occasions, there's actually an incentive for misuse of a False Claims Act. And I think I want to address, I had some testimony, but I want to address Representative Blumenthal's first question about if there's a federal False Claims Act, why shouldn't there just be a state False Claims Act? Well, there's a significant difference between the way the federal False Claims Act is administered and a state False Claims Act would be administered in Connecticut. And that's part of our concern. With the Federal False Claims Act, the U.S. Department of Justice, which is an independent group, conducts an independent investigation and a written finding prior to allowing the Attorney General to pursue a false claims action. In Connecticut, there won't be that independent review. The independent review will take place within the Attorney General's office. And we are concerned that there may be times when there's a legitimate construction claim or a legitimate negotiation over claims on a project. And because the definition of claim is so loose that someone will be accused of filing a false claim. Or it may be used as a counterclaim in a lawsuit just to discourage claims by contractors. I've probably seen as many cases as abuse as the Attorney General could point to of cases where you need this. I don't know if the anecdotal cases are really helpful to everyone, but we think, you know, in my opinion, maybe some of the big contractors, you know, have the resources. They have ethics and compliance programs in place. They have compliance officers. They have the ability to withstand and participate in a long investigation and protracted litigation, and to litigate one of these cases to the point where it could be resolved. But the smaller contractors don't have that. Mid-sized contractors don't have that. And we're concerned that, you know, with these loose legal standards and these low standards of proof, that a lot of these mid-sized and smaller contractors are not going to be able to survive.
Mr. Schubert,
yes.
Your time's elapsed. If you could summarize.
I'm sorry, Senator. Yeah, I guess we think this is a little bit unbalanced. We are concerned about the whistleblower complaints and how it's used by disappointed bidders in some different cases. It's all in my testimony, Senator. And with that, I'd be happy to take any questions.
Thank you. Senator Lesser.
Yes, thank you, Mr. Chair, and thank you, Mr. Schubert. It's good to see you. I take Attorney General Tong at his word that he's looking to address some very serial concerns that we've received in Connecticut very recently regarding various contracting issues. My understanding is that the bill before us is modeled on the New York State False Claims Act. Are there specific issues there that you think that New York has problems attracting contractors? I guess I'm not sure I fully understand your concerns.
Our concerns, you're right, Senator. It is based on the New York statute. It's very close to some of the other state false claims act statutes. We're concerned that without that independent investigation first and a determination on whether to proceed with the false claims action, that this could potentially be abused. And I guess one of the other things that I'm really concerned about in Connecticut right now is these whistleblowers or key tam cases. Disappointed bidders in Connecticut have had success challenging the Department of Transportation's decision on whether or not a low bidder is qualified or properly did their submittals to receive the bid. And we've seen cases where disappointed bidders have used the State False Claims Act trying to get leverage in a bid dispute. And, in one case, I think the California Attorney General, who is the alleged victim of the false claim, filed the motion to dismiss because he realized it was a disappointed bidder that was using this. And those are the sorts of things we're concerned about. We would love to have Attorney General Tong to have the ability to go after the less scrupulous contractors in this. The last thing I like is when the good contractors are sitting on the sidelines and there's other contractors out there, doing different things to gain an advantage in the marketplace. We think it would be really important for Attorney General Tong to have some more authority to help clean that up. But we're concerned about just the broad standards, the low legal standards, the high penalties and damages, and how all that just creates an incentive for abuse, not just by public officials, don't get me wrong, by whistleblowers as well. And when you have competitors bringing whistleblower or false claims actions against their competitors just to be the low bidder, I don't think that's the kind of behavior we want in this state.
So my question, I guess, and sort of building off of your, my understanding is in a key tam action and a false claims action, the Attorney General would have to sign off if a whistleblower comes forward and alleges that there's corruption and wants to bring a false claims action. The Attorney General first has the opportunity, an obligation to investigate the claim and allow, make a decision about whether a case should go forward. So you're saying that you don't have confidence in the Attorney General's office to make that adjudication? Is that what you're saying? Is there another office that you would have confidence in?
I think the Attorney General could do a rather good analysis at that point. I think what those key tam actions can be bought independently. The attorney, in my mind, and I may be wrong about this, but I think the Attorney General decides whether or not the state wants to join in that action.
I think and maybe this is, I'm not an attorney and I don't want to practice laws, particularly in front of an audience in the Judiciary Committee without a license. But my understanding of the way that this statute is constructed is that not only does the Attorney General have the ability to join an action, but he also has the ability to prohibit an action. That the Attorney General really has operates a traffic light, and yes, he can allow private litigation to go forward, but he can also stop it from going forward if it violates public policy. That's been my understanding. And if there's someone on the committee who knows better, please don't take legal advice from me.
No, if that's the case, Senator, I think that's a very important safeguard that we have in Connecticut. I think you're right about that.
Thank you very much.
Comment or question from other members of the committee? Comment or question? Seeing none, Mr. Schubert, thank you very much for joining us this morning, providing us with your testimony.
Thank you very much, Senator.
Have a great day. Next, we'll hear from Shelley Davis. Shelley Davison. Shelley Davis, followed by Kimberly Glassman. Kimberly, Kimberly Glassman, I'm in the meeting. I'm in the meeting. Kimberly Glassman. I see. There you are. You may testify.
Oh, I'm sorry. I thought Shelly Ann was before me. Hi, good afternoon. Chairman Winfield, Chairman Staffstrom, distinguished members of the Judiciary Committee. My name is Kimberly Glassman. I'm the director of the Foundation for Fair Contracting, and I'm actually here to speak in favor of two bills today. The first is SB 366, and that is an act concerning it's a wage theft bill that we worked with the Attorney General's office on to spur debarment proceedings regarding any underpayment or non-payment of prevailing wage rates. What this bill seeks to do is to address some issues that were raised by a task force that the legislature unanimously passed in 2019. This task force was made up of various agencies of the state, the Attorney General, DAS, DOL, UConn, DOT, and the purpose of this task force was to study why the state does not debar bad players who have state contracts, who've had multiple wage violations. What is the issue here? And the task force came up with a number of recommendations. They issued their report on January 31st, 2020. That report is attached to my written testimony, so I'm not going to get into the details of it. But what this legislation seeks to do is to try to move the dial and address some of the issues that were raised in that task force report. And so we appreciate working with the Attorney General's office on this. We think this is a good piece of legislation. I'm certainly happy to answer any questions about this particular legislation. I also wanted to speak in favor of SB 426, which you just heard about both from the Attorney General and from the speaker previous to me, which is the Attorney General's bill to expand their authority under the False Claims Act. We think that this is a tool in the toolbox for curbing wage theft violations, and it mirrors very much the federal False Claims Act. And there are a number of states around us that use the State False Claims Act to recoup lost wages. New York, Pennsylvania, Maryland, just to name a few, and certainly can give some examples of some states, some of the success that those states have had with false claims. But ultimately, wage theft happens in the construction industry. We know it happens in the construction industry. I've been before this committee before, usually before labor.
Your time elapsed, if you could summarize.
Yep, these are two steps, these are two bills that help to curb and disincentivize bad players from abusing or exploiting their workers. So again, happy to answer any questions. Thank you.
Thank you. Senator Lesser?
I'm happy to let Representative Fishbein go first since he's the ranking member.
Representative Fishbein.
I really have no preference, but that's fine. But then he gets the last word. Is that really fair? I defer back. No, I'm kidding. I'll take it.
I have no ulterior agenda, Representative. I can go either way.
Representative Fishbein, proceed.
Okay, thank you. Hi, Kim. Nice to see you here instead of labor, right?
I know. Nice to see you, Representative.
So the prevailing wage bill, am I to understand? So contracts, municipal, well, some state contracts also, are required to have a prevailing wage provision, therefore requiring the contractor to pay their subs a certain rate. Is that fair to say?
Yes.
And the problem that we're addressing here is where the contractor hires the sub under the auspices of having to comply with that prevailing wage requirement and pays the sub less than what they required under the contract. Is that fair to say?
Well, it's not really the sub, right? The sub is also an employer. So any contractor is required, if prevailing wage applies to a construction project, municipal, state construction project, then the contractor, whether they're a prime contract holder or a subcontractor, they are required to pay their employees the posted prevailing wage rate per what the classification of work that employee is performing.
And it is the contractor that contracts with the state that agrees to the prevailing wage, and they're required to assure that everyone down the chain complies with that, correct?
Yes, that's correct.
Okay, so it's where there's a deviation in that contractual arrangement, we're giving the AG's office the power to enforce.
But I want to, yes, but there's an important provision here where it's if the Department of Labor has found a contractor to be in violation 2 times within a 5-year period. So, look, there's companies that are new, have formed new EIN numbers. They are new into the prevailing wage world. Maybe they usually do like residential construction work or private work, and they're new into the prevailing wage world. And maybe they don't know all the reporting requirements. They don't know exactly how to fill out a certified payroll record. And we want to make sure that we're allowing for contractors. I'm a labor management organization, so I represent contractors too. And we want to allow for companies to, maybe they make a mistake, and that's not, and certainly if they made a mistake 10 years ago, this shouldn't apply, right? This is if a company has I think shown the state that they are unwilling to comply. If they have 2 violations within a 5-year period, it triggers for the commissioner to send this case or the contractor to the Attorney General to review and see if they can recoup back wages, civil penalties. They then can issue citations and begin debarment proceedings.
Okay, no, I thank you for that. And that really helps, the public testimony on this, because I know in labor, we talked a lot about enforceability and debarment proceedings and bad contractors, and I know you and I talked a lot about what do we do for teeth. So, but moving forward from there, 426, the way I read this is presently there is protections for government when there is fraud. That's how the law presently exists. This removal of the provisions having to do with government engagement brings it into the private sphere. Is that fair to say?
I can't speak to that. I can't answer that question. I am also not a lawyer, and I don't want to speak out of turn as to what all of the statutes that every agency has in terms of being able to recoup lost revenue from a state contract. I don't know every provision. What this bill seeks to do is to sort of mirror a couple of other states around us where it also would mirror the Federal False Claims Act. So it would allow a party to, and we'll use my organization as an example because my sister organizations in Pennsylvania and New York were the ones that brought the False Claims Act, brought a case under the False Claims Act in their states. And what this would allow an organization like mine to do, if we believed that a state contractor had egregiously violated the law, let's say that they had been putting tens of millions of dollars in wages fraudulently into a fraudulent 401k account, or they weren't putting their contributions into a 401k account. I'm using as an example, something very fraudulent. In this certified payroll record of their projects showed that they were showing we're putting this contribution in and they're filling it out. if we believed that that company was in violation and it met the standards to move forward with the false claims, we would file that case. We would hire an attorney. We would file a case in court under the False Claims Act. And under this bill, the Attorney General would then look at this and decide, do we feel that this state contractor has egregiously violated the law, has exploited its workforce, and therefore has also hurt the state of Connecticut in terms of lost tax revenue and hurting Connecticut workers? And is this a case that the Attorney General wants to take on? And if they decided to take it on, one of the benefits to organizations or parties that decide to move forward with the False Claims Act is that they would, if the court found in their favor, there would be some financial benefit that would come back to the person who filed, or to the entity that filed the case. If the Attorney General does not take the case, the Attorney General says, you know what, we don't think this is strong enough, or whatever the reason is, then the whistleblower or parties still can move forward with the false claims action. They would just do it with their own means, right? They would go forward with their own attorney, and they would not, even if the courts found in their favor, they would not receive any damages. That was the word I was looking for. It would only, whatever lost wages or whatever monies that had to be returned to the state, that's what the court would focus on. And I believe that that's the same case in New York. I don't know if that answers your question or not.
Well, I don't look at other states a lot of times. I'm looking at the language before us, but my concern with this is it removes the clause repeatedly. Presently the law has to do with fraudulent claims relative to a state-administered health or human services program. So that's the current status of the law. We're removing that clause, which means any relationship within the four corners of our state would become party to this. It does not require that it's a false claim against the state. For instance, in 49 through 50, it has to knowingly present or cause to be presented a false or fraudulent claim for payment or approval. That's prohibited. So it doesn't say in the context of an employment situation. It could be in any situation. So no person shall knowingly present or cause to be presented a false or fraudulent claim for payment or approval. I mean, that, and it goes on with many other provisions, knowingly make or use or cause to be made a false record or statement material to a false or fraudulent claim. That could be, under the four corners of this language, a complaint to the police department that your car got stolen, but it was really your child that took it, something like that. That's a false or fraudulent claim, and we're inserting the Attorney General into all of these relationships. So I understand your intention of the application of this language, but and I perhaps agree with you with where you want to get, but I'm just very troubled by the length and the breadth of this. So I thank you as always for the discussion, and thank you, Mr. Chairman.
Thank you,
Representative. Senator Lesser.
Yes, thank you, Mr. Chair, and thank you. I was always happy to defer to Representative Fishbein. Just one quick question about your organization, because I did see you're testifying in support of the False Claims legislation. Your organization represents, in addition to labor unions, it also represents contractors as members. Is that right?
Yes.
Okay, great. Thank you. That's very helpful. Thank you.
Thank you, Senator Lesser. Comment or question from other members of the committee? Comment or question? Seeing none, Ms. Glassman, thank you very much for joining us this morning.
Thank you.
Enjoy the rest of your day. Next, we'll hear from Representative Holly Cheeseman. Representative, your opportunity to testify is here.
Thank you so much. Thank you, chairs. Thank you, ranking members. It's my pleasure to be here today to testify in support of House Bill 5350, which relates to freedom of speech. A bit of background, this is the third time I've testified on this topic, I believe, prior 2 times in higher ed. And the first time I was in support of a bill proposed by Representative Haddad, which would protect the freedom of speech, specifically of professors on college campuses and our UConn and state universities. If the purpose of a college, of a university, is to support the free and open exchange of views, then affirming that by adopting legislation such as this, affirming the Chicago principles, is indeed a good thing. We've seen throughout the country and attempts to suppress speech, and the Chicago principles indeed were created in response to that and have been adopted by universities throughout the country, including the University of Virginia, the University of Maine system, UNC Chapel Hill, and Princeton University. And why is this necessary? Because speech with which we disagree is equally valid. Indeed, the right to speak freely is among our most precious rights and privileges. I've seen some of the testimony that objects to this on the grounds that we shouldn't be forcing people to listen to speech. We shouldn't force the universities to spend money to create for security for these talks. I find that argument somewhat egregious, given that UConn seems to have no trouble losing $44 million on their athletic program and paying out $11 million legal settlements to professors. But I do think that in order to create the kind of citizens we need, we must affirm on our college campuses throughout the state the freedom to speak and be heard. And I'd like to end with a quote from Frederick Douglass from his speech in Boston on December 10th, 1860. "No right was deemed more sacred by the fathers of this government than the right of speech. It was in their eyes the great moral renovator of society and government. Liberty is meaningless where the ability to utter one's thoughts and opinions has ceased to exist. That of all rights is the dread of tyrants. And equally clear is the right to hear. To suppress free speech is a double wrong. It violates the rights of the hearer as well as those of the speaker. It is just as criminal to rob a man of his right to speak and hear as it would be to rob him of his money." So I am in strong support of this bill, and I want to thank you for giving me the opportunity to come today, and I would be happy to take any questions.
Thank you very much, Representative Cheeseman. Representative Howard.
Good afternoon, Mr. Chairman. Thank you. Good afternoon, Representative Cheeseman. Hearing your testimony, thank you for that. Can you just sort of elaborate, why we need to do this in Connecticut?
Sure. Well, as I say, I think that the University of Chicago principles, which were predicated when we were seeing universities attempting to suppress speech by citing security concerns, by stating that, certain speech was not worthy of being uttered on college campuses. And I think you'd agree, Representative Howard, as I hope everybody on this committee would agree, we gain nothing by shutting people up. As we engage in our activities in the chamber, we argue about emotional things. We argue about issues over which there are many, many differing views and strong feelings. But if we were to have the speaker say, "I'm sorry, we can't discuss this because I see it's upsetting to, so-and-so, what representative," we would not have a deliberative legislative process. How can we raise a generation to engage in robust debate to be able to hear words with which they may not agree, to not have the ability to counter those words with words of their own. Where would the women's rights movement be, or the civil rights movement, if everyone who had ever uttered words to which they, with which they disagreed was made to shut up? Open and robust debate is to be fostered. And I think for our colleges and universities in our state university system to say, you know, I may disagree with what you say, but I will defend to your death the right to say it, is an important principle that should be enshrined in statute.
Thank you very much. Thanks for being here, for testifying with us today. Thank you, Mr. Chairman.
Thank you very much, Representative Howard. Is a comment or question from other members of the committee? Comment or question? Seeing none, Representative Cheeseman, thank you very much for joining us this afternoon. Enjoy the
Thank you.
Next, we'll hear from Joe Toner, followed by Jenna Sternberg. Joe Toner.
Hello, Chairman Winfield, Chairman Staffstrom, Ranking Members Kissel, Ranking Members Fishbaum, and distinguished members of the Judiciary Committee. I'm here to speak on SB 366, and that concerns civil penalties for failure to comply with prevailing wage. I am the executive director of the Connecticut State Building Trades. I proudly represent over 30,000 hardworking men and women that are actively employed in the construction industry. And we also represent our retiree sector, which would probably number up to 50 to 60,000 folks. So as you can see, we have a large workforce, and we're very concerned about the erosion of work rules in the state of Connecticut and enforcement for prevailing wage rate jobs. The Connecticut Department of Labor does a phenomenal job in enforcement, but unfortunately our statutes are so weak that the folks that continue to cheat. And what that does, it puts good union and non-union contractors at a disadvantage. We had a contractor, Ferguson, as many of you are probably aware of, who actually embezzled, I think is a better word, close to $4 million from their employees over a course of time. They're still bidding work today in Connecticut. They've been bidding work while they were stealing money. They're still eligible to bid work in Connecticut. $4 million isn't a mistake on a certified payroll. $4 million is a business plan. And what's happening here in Connecticut is our rules, our laws are so weak from surrounding states that the bad actors that are being disbarred from New York and Massachusetts are coming to work in Connecticut, and they're not leaving. Their business plans fitting in Connecticut. Meanwhile, the workers money is being stolen from the workers at a phenomenal rate. And these contractors continue to win awards on state prevailing wage rate projects. So we have to put more teeth into these laws. It's not a union issue. There's many good open shop contractors that our Contractors Association bids against, which we welcome that competition. But when people continue to come in and steal money from their employees that worked very hard for it and pay back a quarter on a dollar and nothing happens to them, and then they go bid the next job and do the same thing over and over again, it leaves everybody in the state of Connecticut in the construction industry at a disadvantage. So we strongly hope you would consider the passage of this bill. It's much needed in the industry. I will take any questions, and thank you for the time.
Thank you very much, Mr. Toner. Representative Fishbaum.
Thank you. Good afternoon, Mr. Toner. I know with residential contractors, DCP has a place that you can go on their website to see if there's been complaints against them. Am I to understand, I think what you're talking about is these large commercial contracts, that kind of stuff. Is there some, I'm a little surprised that the state, which is awarding these contracts, isn't keeping some sort of record of bad actors. Am I correct at that?
Yes. So I think part of this bill, it just starts with it, but I think the other part of it is the qualification process through DAS, Representative. So we have to get to the point where the bad actors aren't qualified to bid on these projects. And that's not through the Department of Labor, that's through the Department of Administrative Services. So there's actually two parts that would actually make this viable to make sure going forward that these bad actors don't continue to do business in Connecticut.
Okay, and am I to understand, because I didn't see that portion of the bill. I thought that this merely 366 empowered the Attorney General's office to enforce the underlying contract. I didn't see a portion of this, and perhaps I missed it, where it prevents those contractors from bidding on contracts.
No, it's not in there, and it's something that we have to continue to work on. And we've had a task force that met with all the commissioners and all the people, all the stakeholders in the construction industry. And due to COVID, the task force doesn't meet any longer. So that's language that we are also trying to incorporate. So we want to make sure we're trying to also incorporate that language as we move forward in this process.
I appreciate that, and you know, I don't know whether or not the state through DAS to its regulations can do that without a statute, because it would appear that,
yes,
you know, if I own a business and, you know, I buy pencils, you know, once a month or so, and, you know, business didn't abide by the contract, at some point I say, I'm not buying pencils from you anymore. I don't know how the state operates in this fashion when they enter into a contract, the other side doesn't comply with the contract, and yet they're just asking for more trouble. So I'm sure we'll have discussions in the future, but thank you, sir, for coming here today.
Thank you.
Thank you, Representative Fishbein. Senator Kissel.
Thank you very much, Mr. Chair. Mr. Toner, I'm trying to go back. Are you my constituent? Do you live in Enfield?
I got good news and bad news, Senator. I was, but I moved. We moved, actually.
So where'd you move to?
I'm in Quaker Hill, Connecticut.
I'm not even sure where that is.
Senator Formica's, Waterford. It's a borough of Waterford.
Oh, you didn't move. You moved far, like from end to end.
Well, the kids all moved out of the house, so now it's our turn, right?
There you go. All right. Well, thank you so much. It doesn't matter. Really appreciate you coming to testify today. And you guys submitted written testimony?
Yes. Yes.
All right. So I'll look at that as well. But your points are well taken, and I wish you the best down by the shore.
Senator Kissel, nice seeing you. And it was a pleasure being your constituent up there. Even though we weren't on the same team a lot, we have a lot of respect for you. You do a great job for the folks in Enfield. So thank you.
Well, thank you. And likewise, I feel a ton of respect for you folks as well.
Thank you very much, Senator Kissel. Comment or question from other members of the committee? Comment or question? Seeing now, Mr. Toner, thank you very much for joining us this afternoon.
Thanks for
next we'll hear from Jenna Sternberg, followed by Ron Tadosian. Sorry if I messed that up. Jenna Sternberg.
Good afternoon. I'm here to testify about House Bill 5464, which has to do with the change to the Connecticut homestead exemption. And to stress that the change is necessary, but the language that's proposed doesn't go far enough. I presently represent an 80-year-old woman who has been treated as the test case in the Hartford Bankruptcy Court for use of the full $250,000 exemption. We expect a ruling from the bankruptcy court shortly. I also have a gentleman in his mid-70s who's got a similar issue. This is very relevant to everything that's going on in the bankruptcy practice. When Connecticut first implemented the homestead protection in 1993 in the amount of $75,000, the Public Act enabling it made clear that it only applied to liens arising on or after the effective date. This made sense because, well, very shortly afterwards, litigation followed that went up to the Second Circuit. And ultimately, the Second Circuit determined that the creation of the new homestead protection was a substantive change in the law because it made this, this event that didn't exist before, and based on fairness, it could only apply to obligations that were in existence after its effective date. A substantive change to a statute creates, defines, and regulates rights, and is generally applied prospectively without a clear intent to have it apply retroactively. The 2021 amendment did not have such language in increasing the amount to $250,000. This makes sense because the change didn't create a new right. It just provided long overdue change in the amount of the protection available to our homeowners in an effort to keep up with the changing times. And a procedural change to a statute affects the method of enforcing the rights or obtaining redress and leaves the pre-existing scheme intact and is generally applied retroactively. If you look at the federal counterpart, their homestead exemption and their other exemptions increase every 3 years on April 1, and there's never an issue about applicability when that's done. This increase is remedial. It's supposed to protect our homeowners, and it's hard to imagine a public policy reason to limit the application only to debts that have incurred after October 1, 2021. The effect of that, if that's what happens, is that the bankruptcy court process is going to be left to try to determine which obligations were in place before October 1, 2021. And those obligations the debtor would have the use of the $75,000 exemption. But if the obligations came about after October 1, 2021, the same debtor would have obligations that would be, I'm saying that backwards. If it was, the later debts would only apply the $75,000. The earlier, I'm still saying it backwards. But the bottom line is there would be the scheme that somebody in the bankruptcy process would need to determine when a creditor's obligation came into play, and the same debtor would be using different exemptions to treat those obligations. It will be confusing and expensive and make an already difficult process that much more difficult.
Attorney Sternberg, your time has elapsed. If you can summarize.
The original enactment created a new right in 1993. The 2021 amendment did not. It just updated the existing scheme to provide our residents with better protections and the best chance of moving forward.
Thank you. Representative Fishbach.
Thank you, Mr. Chairman. Good afternoon, Jenna. I'm just, when we were screening this, we were trying to say, is this an issue? So when we passed this, it was my understanding that applications for bankruptcy filed after the effective date would be able to take use of the new state exemptions. Is there a problem with that?
The problem with that is that attorneys that are appointed as the bankruptcy trustee have taken the position that because in 1993 that wasn't allowed, this is a similar situation. So the bankruptcy trustee in my two cases has challenged my debtor's ability to use the $250,000 exemption. And it's become this whole disagreement about whether the change in the statute is considered procedural or substantive. That's the legal fight that's been going on in the bankruptcy court so far.
So has the bankruptcy court ruled on that particular issue?
It has not. There was a hearing that took place on March 4th, and the judge had made clear that he expects to rule swiftly.
Okay. So is it possible that this legislation is premature, given that that decision has not been made?
I don't think so. I think it's more necessary because I suspect the change from a $75,000 to a $250,000 exemption, that's a whole lot of money, whether it's the debtor's money or money that's going to be used after the trustee sells our resident's home and pays unsecured creditors. So I understand that if we're successful in our position, there may likely be an appeal. So it would be very helpful because it would be very helpful to know why the legislature did what it did. It will help that process all along the way to somebody's benefit. And I'm hopeful that it will be to the residents' benefit and not the creditors.
And in these two cases that you referenced, they were both filed after the effective date of this latest change, correct?
Correct. One was filed on October 1, one November 22nd, I believe.
Okay. And the position of the trustee, because we've asked for some sort of briefs that have been filed, and this has been my first opportunity. I've gotten no documents. This is my first opportunity to delve into this. So those post-enactment filings sought to make use of the $250,000 homestead exemption. And the position of the trustee is what exactly?
It only applies to obligations that are incurred after the effective date of October 1, 2021, because that's what happened in 1993 when the homestead exemption was created.
Okay, I understand. And in 1993, that interpretation, I haven't looked at what happened then, right? With that understanding, that interpretation was dictated by attorneys practicing, or was there a court decision that interpreted it in that fashion?
There were two things. First of all, the Public Act specifically said the act shall take effect October 1, 1993, and shall be applicable to any lien for any obligation or claim arising on or after said date. So that was point one. And then
that's different though than here, correct? We did not include that language.
Right, absolutely. That did not happen now. The second thing that happened is there was a challenge in the bankruptcy court to a debtor's use of the homestead exemption. It went up to the Second Circuit, which adopted the bankruptcy court decisions, which basically said, this is substantive. It's a new right that never existed before. And the Public Act specifically says it doesn't apply until after it existed. And in fact, one of the decisions said, well, on the bankruptcy level said, maybe it would be different if the legislature didn't have that language. We don't have that language here. It doesn't make sense in our present situation where you're not creating something new. You're just trying to come up with the times and protect our homeowners.
So based upon the way that we passed this statute without providing for that carve out, I would think that by default, the court would side with you. I don't want to speak for the federal court process and all that stuff, but I think what we passed was sufficient to meet the intent. I just add, when and if that decision comes down in the next week or so, can you please forward it to the testimony link, or forward it to our office, because we may need to deal with that, but it appears that the omission of that language, at least in my opinion, would therefore open it up to the petition and not the debt, and therefore resolving this issue. So I really appreciate the discussion, because I've been waiting for this, most of the session, quite frankly, very dry. But thank you, Mr. Chairman, for the opportunity.
Thank you, Representative Fishbein. You actually asked questions I was going to ask, so thank you very much. Comment or question from other members of the committee? Comment or question? Seeing none, Attorney Sternberg, thank you very much for joining us.
Thank you.
Ron Titosian, followed by Ed Hawthorne. Don't see Ron. Ed Hawthorne.
Good afternoon, Senator Winfield, Representative Safstrom, and members of the Judiciary Committee. My name is Ed Hawthorne. I'm proud to represent over 200,000 working men and women as the president of the Connecticut AFL-CIO. Thank you for the opportunity to testify on this Friday in strong support of SB 366, an act concerning civil penalties for failure to comply with prevailing wage laws. You have my written testimony. The study's been mentioned earlier. I just want to highlight specific portions of it. That report, it's not the agency's practice to refer these matters to the state's attorneys, nor the agency's practice to seek a debarment of contractors. This bill is meant to target contractors that are repeat violators that keep coming in, almost using this as a business model of undercutting those prevailing wage laws in order to, go, I guess, around or in front of, in this case, those responsible contractors that should be getting these contracts. It directs the labor commissioner to refer contractors' violations which have occurred within a 5-year period to the attorney general, who have the authority to recover the unpaid wages, any civil penalties, and initiate those debarment procedures. This has occurred in New York and Pennsylvania to great success. Pennsylvania has recovered $20 million in unpaid wages from a state contractor for failing to comply with the law. And, it really does, like I said before, target those unscrupulous contractors that we need to hold accountable to really level the playing field for the ones that we should be supporting, the ones that follow the law, follow the rules, and pay those workers. I mean, we're talking about people that pack a lunch up before the sun rises and leave a lunch on a table. They often eat a lunch, sitting against the wall on their lap, and they work hard and they deserve to be paid a fair wage for it and what the contract calls for. So I thank you for the opportunity to testify. I'd be happy to answer any questions that you might have.
Thank you very much. Representative Fishbein, I see your hand. Was that from before or?
Yes, I'm sorry. It was from before.
Okay. Comment or question from other members of the committee? Comment or question? Seeing none, thank you for joining us again. Mr. Hawthorne, enjoy the rest of your afternoon.
You too. Try to get outside. It's nice and warm, everyone.
It sure is. Next, we have Melissa Linden and then David Falvey. David Falvey, are you in? I see David Falvey, followed by Diane Lauricella.
I'm Dave Falvey. I'm here.
Okay, you may testify.
Right now or when?
Yes, right now.
Oh, okay. Thank you.
We don't just so that you know, we don't see you. So if you could turn your camera on, please do. If it's
Let me
not,
ask my staff to help me. Oh, let me see. Start the video. Oh,
Yeah.
Maybe I did it.
there
Okay.
you go. Perfect.
Okay.
You can
Bingo. I
testify.
can't believe it. All right. Hey, good afternoon. Good morning. Oh, afternoon. Good afternoon, everyone. I'm here about House Bill 5464. I'm Dave Falvey, and I'm in Groton, and I'm an attorney, and my practice is recognized by the federal government as a debt relief agency. Regarding House Bill 5464, an act concerning the homestead exemption, I'm here to support the proposition that the new homestead exemption be applied retroactively and prospectively by adding appropriate language to the bill, and I support new language. What Senator Fishbein just said, I really agree with, but sometimes it needs more clarification so that the creditors will sit up and take notice and agree with the obvious. I have submitted a paper of approximately 8 pages, and in my paper, I review the history of debt relief from chapter 15 of Deuteronomy and Leviticus through the Roman Empire, through the 18th century England, and of course, the United States. The issue before us today is simply freedom. Freedom from debt, and debt was the legal construct for all slavery in this country and indentured servants. If a Black person prior to the Civil War, American Civil War, could raise the money, I don't know how they did it, and pay off the debt, they were given a manumission papers and they were free, even though notwithstanding people would look at those papers and say they were forged. I compared Florida and our sister states, New York, Massachusetts, Rhode Island, and how they have handled the homestead exemption. The homestead exemption is reviewed in my paper and how it would shape the American experience. I have said that America has many faults and many failings, but the bright star on the Statue of Liberty that illuminates and inspires the entire planet is summarized in one word: freedom. And if I may digress, this is what is inspiring Ukraine today. One word: freedom. You have before you a piece of legislation which will greatly help the average citizen in our time, in our economy, keep their home and shelter and keep their family together. Our homestead exemption has not changed for the last 20 years and it's outdated, as most know. I repeat, it is not kept pace with the times and is outdated. It has to be updated to insert language into the legislation that makes it very clear and simple, especially for the creditors, that this bill applies to debts prior to October 1st, 2021 and debts incurred after 2021, October. You may save your many homes for the average citizen, and you'll keep families together for generations to be born. And this is the American tradition of a homestead exemption, which is outlined in my submitted paper. Any questions? I'm glad to try to answer them.
Thank you, Mr. Falvey. Comment or question from members of the committee? Comment or question? Seeing none, Attorney Falvey, thank you very much for joining us this afternoon and providing us with your testimony. Enjoy the rest of your day.
Thank you. You too, and everyone.
Next, we have Diane Lauricella, followed by Jen Lawler and Olivia Rinkus. Diane Lauricella, Jen Lawler, Olivia Rinkus, you are on. I see you in the list. Olivia Rinkus.
Hi, thank you. This is Olivia Rinkus. And thank you to the Judiciary Committee for the opportunity to.
One thing, Ms. Rinkus, thank you for joining us again. Your camera is not on. If you can turn it on, if not, please proceed.
Yes. Thank you. And thank you to the Judiciary Committee for the opportunity to testify. I just wanted to make some comments on some bills as a concerned citizen. The first bill was, excuse me. The first bill was SB 435, the act concerning the permissible recording of a private telephone conversation. I'm in no way a legal expert, but I was just somewhat confused by this bill, and I was just concerned if this gives the recording party the ability to record without any knowledge whatsoever of the person being recorded. And I just hope that legislators keep that in mind when they are discussing this bill further. And also regarding HB 5350, an act requiring public institutions of higher education to establish a policy protecting freedom of expression on campus. I definitely agree with the intention of this bill, but the way it's worded just is so curious to me. If it would give the public institution the ability to determine what constitutes freedom of expression. And I also hope the legislators keep that in mind. And thank you very much for the opportunity to testify.
Thank you. Comment or question from members of the committee? Comment or question? I see none, but I have to say that you join us so often in so many committees that I really appreciate your effort to participate as a full citizen. Thank you very much, Ms. Rinkus. I am sure that we will see you again. Enjoy the rest of your afternoon. Next, we have Amy Borden, followed by Don Doig. Amy Borden, I do not see. Don Doig. There you are.
I'm Doig, yes, okay. Good afternoon, Chairman Winfield and Chair Sastrom and members of the committee. My name is Don Doig. I am testifying on behalf of ACEC, American Council of Engineering Companies, in opposition to Senate Bill 426, an act concerning false claims. I have submitted the ACEC's position regarding this bill in written form. And since that testimony is very similar to that, which you've already heard from Attorney Donnelly and Attorney Schubert, and what they've already presented, I'm not going to simply reiterate it now, but I will adopt their positions and concerns, and we share those with the ACEC. I would like to take my time to address one particular issue that's of noteworthy concern, and that's the breadth of this bill as worded. Some of the key terms are either broadly defined or not defined at all, and this could be interpreted broadly and cause issues within the industry. And I'm specifically now, I'm referring to the construction industry, and that's my biggest concern. A claim is defined to include any demand or request for payment for money or property. In the construction industry, that would take many forms: payment requisitions, change order requests, and there's a lot of documents there that I guess could be officially a claim. But the issue comes, one of the big issues for me comes to the term false. I mean, the title of the act is for false claims, but the term false is not defined at all. And if you, throughout the act, there's some references to false and fraudulent, which would imply that there's a distinction between the two, but false is never defined. And false, I think, opens the door to a lot of potential claims and issues. If you take Webster's dictionary, false, it defines false as not true. I mean, and I think that's still there's a broad distinction. There's a lot of issues that come that way. There is not a bright line in many construction issues and engineering issues. In construction and engineering, there are many issues that are not completely black and white, and they're subject to interpretation. Experts are often retained by the parties to opine about some of these particularly technical or detailed issues, and the parties rely upon their experts' opinions. The question then arises is, at the end of the day, if there's a dispute and the party seeking a change order, experts are not believed, did they make a false claim? Are they subject to the terms of this provision? There's nothing in this legislation that talks about good faith. It's knowing that if we good faith relied upon our expert and made a claim, made a payment application, it doesn't matter. You made the claim, you submitted a change order, you submitted a payment application, you did it in good faith, but technically what you put down there, ultimately your expert's not believed. And I think that opens the door to many problems. I agree with testimony to date that we need to address egregious situations, which maybe are fraudulent, or how we define those to really parse out some of the bigger issues. But I think as currently worded, there are significant claims that could arise under this statute for people acting completely in good faith and in terms of what has gone on for decades in the construction industry.
Your time is elapsed, so I just
Fair
want
enough.
to be
Thank
aware
you.
of that. I'll go to Representative Callahan.
Thank you, Mr. Chairman. Thank you for coming in, Mr. Doig. Was there any other portions of 426 that you had concerns about?
I think in terms of language, I mean, my biggest issue was exactly what's covered, and that's defined in different places. I do think it somehow needs to be redrafted to make it a distinction, and really that I think they actually go against the fraudulent claims, the really egregious claims, and other parts of it would have to be reworded to get to that. Because I think it sets up a condition, and I will say this, and one of the things I've heard from other states, and I'm not an expert in New York or the federal, and I think Attorney Schubert probably can talk to that, and his brief did talk to that more. But some of the issues that people have, they're afraid to make the false claims because of the recovery of the fees from the state, whoever's bringing the claim. And so people in good faith make a claim and they're pushed back. And I've heard instances of people getting pushback from the state or the private citizen saying, hey, this is technically a violation. And if I win, you got to pay my fees. And people capitulate. And they're put in an unfortunate position as currently worded. So I think there's got to be some massaging of some of the language here, just to signify that it only applies in the more egregious situations.
Well, your testimony is valuable to me today, and I appreciate you coming in and taking the time. Thank you, sir. Thank you, Mr. Chairman.
Thank you, Representative Callahan. Coming to question from other members of the committee. Coming to question. Attorney Doig, I'm not an attorney, so I'm asking you this question in your capacity as an attorney who may understand this better than me. You suggested that it was unclear what false means, but we're expanding a statute we already have to touch on more. Are you suggesting that it's unclear currently what false is?
Well, I think it is. I think in terms of this language, the title of the act is an act concerning false claims and other prohibited acts. So we're thinking it's false. But throughout the language, when you're making the definitions, there's the concept, it doesn't refer just to false, it refers to false and fraudulent, almost consistently all the way through, which would imply, once again, this is just logic of what somebody might argue in court in front of any other committee, that there's a distinction between the two. Neither are defined. Fraudulent makes sense, but what is false? Is false just somebody, it's false that somebody made an adding error. That's false. It's false that somebody transposed some numbers, but good faith submitted it. That's false. That is not correct. Those numbers are wrong, but there's a good faith effort to do what needs to be done. So I think when you get into the false inclusion into this act, it opens the door to some minor transgressions that are completely in good faith, but would subject the person that submitted it to some horrendous penalties.
And I recognize the point, and I was just asking you, I know what the statute says and or would say, should we change it? But I also recognize that any of the things we do also have the body of law that grows up around them. And so as a person who would know this, I was asking, because I hadn't heard today, I don't think anyone suggested we didn't know currently what false is. If your opinion was that we didn't know what false is as it currently is constructed.
If I may, just, I
Of
think
course you may. Yeah.
where I'm coming from is I think in other areas, it's a lot clearer. It's black and white, it's right and wrong. I think what I tried to emphasize and probably did not do it well was in construction, it becomes gray and murky. There is no clear right and wrong. There are so many issues that are subjective to different opinions that it becomes much more difficult than in many other areas in the construction industry to determine what is false. You can make a good faith opinion, but you could ultimately, court could prove you wrong or somebody else could prove you wrong. And then you were false. What you had advanced was wrong. You would argue that it was decided by the court. And I think construction's somewhat unique and getting grouped into this bill. Many other areas it's right or wrong. It's easy to distinguish. It's not easy to distinguish in construction. I've been doing this for 30 years. Almost everything has two different sides of the story. And in most cases, there's good faith sides to both sides of the story.
Well, I want to thank you for engaging with me. And it looks like there are no further comments and questions from members of the committee. So engaging with the committee as well. It's valuable information you shared with us. Thank you very much. Enjoy the rest of your day.
Thank you. Thank you, everyone. Have a good day.
Next, we'll hear from Michelle Voigt, followed by Kathy Flaherty, and then Susan Williams. Is Michelle Voigt here? Kathy Flaherty, Susan Williams. I had seen Susan. I don't know if she's still there. Scott Chamoy. Scott Chamoy. And Minuski. And Minuski. I see Scott Chamoy. Are you there? Wait, I see. Okay, here's what we're gonna do. I just saw Michelle Voigt pop up. So here's what we're gonna do. We're gonna go to Michelle Voigt and then Scott Chamoy because I see both of you on the screen. Ms. Voigt, you may testify.
Thank you. Good afternoon, Senator Winfield, Representative Staffstrom, distinguished members of the Judiciary Committee. I am Michelle Voigt. I am the co-founder of Violent Crime Survivors. I am testifying today in strong support of SB 434. If someone set out to design a system to provoke symptoms of post-traumatic stress disorder, it might very much look like a court of law. The court system is a high-risk space for a survivor of trauma. To promote healing, a survivor needs social acknowledgement, control over their lives, and an opportunity to tell their story on their terms. From airport-like security, public challenges to their credibility, crime scene evidence and photos, encountering the perpetrator, the courthouse can be a minefield of traumatic stimuli. Too often, crime victims experience a second assault by a system that disregards and undervalues them. By understanding how trauma impacts crime victims and how the criminal justice system can re-traumatize a victim, prosecutors can begin to reframe their interactions with victims. Some studies have in fact found that positive experiences in the justice system are associated with less physical and psychological distress and better post-traumatic adjustment. To add salt to the psychological wound, the criminal justice process protects the offender with constitutional and statutory provisions while the victim is not even a party to the case. Research has found that 71% of victims have lifetime post-traumatic stress disorder, which might be attributable to aggravation of symptoms produced by interacting with the criminal justice system. A trauma-informed approach recognizes signs of trauma and places priority on restoring the survivor's feelings of safety, control, choice. Currently, victims are instructed to remain at the court during jury deliberations with little to no notification that the verdict will be called. The instruction holds victims hostage in courthouse hallways for countless hours and days. Victims, afforded few rights in the criminal justice system, must have the ability to retreat during jury deliberations. It is reasonable that they have adequate time to travel to the courthouse from their home, employment, place of refuge, to be in the courtroom when the verdict is announced. Criminal court proceedings occur in the court jurisdiction where the crime occurred, not where the victim resides or they're employed. Victims travel back and forth daily to attend often lengthy trials. Victims who rely on public transportation and those responsible for child care and elder care are disproportionately impacted. The Crime Victim Rights Act and state statute protect victims' rights to dignity, respect, and privacy in the justice system. It's time that we view statutory protections as a floor, not a ceiling. And courts go beyond, even expanding statutory requirements to pursue trauma-informed justice for victims. SB 434 is a small step in that direction. I appreciate your consideration and I thank you for your time.
Thank you. I believe Representative Fishbein has a comment or question.
Yes, thank you, Mr. Chairman. Thank you, Michelle, for coming here today and for putting a voice and a face on this legislation that's before us. Because you could share, well, and you did share the anguish that one goes through in viewing their accused, the perpetrator who's been tried, and you're just waiting for justice, if you could ever have justice from a guilty finding, and for you to take a moment to go get a sandwich down the street and then perhaps come back to the courthouse to learn that the verdict was rendered. You didn't get to be part of seeing that process, and in my opinion, that leaves it empty. There is no closure. So I think I just want you to know that I am totally sympathetic to what's going on here. I think the language does need some working. I think we consider the concerns raised by the Judicial Branch, but I'm totally there with you. So thank you for coming here today once again. Thank you, Mr.
Thank you.
Thank you, Representative Fishbein. Comment or question by the members of the committee? Comment or question? Seeing none, I think Representative Fishbein said it quite well. Thank you, Michelle Voigt, for joining us this afternoon, and enjoy the rest of your day.
Thank you. You as well.
Next, we have Scott Chamoy, and then I see Susan Williams. So Susan Williams may be right after Scott Chamoy.
Yes, thank you, members of the Judiciary Committee, for hearing me today. And I appreciate the time that you're taking to discuss these issues. I'm here regarding HB 5464. I have submitted written testimony, but because I've submitted that written testimony, I'm going to take the opportunity to use my time to follow up specifically on the discussion that Representative Fishbein had with Ms. Sternberg earlier today. Representative Fishbein, it certainly gladdens my heart to hear that this was the intent all along, that the increased $250,000 homestead exemption was intended for immediate use in bankruptcy cases that are filed after its effective date. Unfortunately, as Ms. Sternberg alluded to, the trustee, Chapter 13 trustee and the Chapter 7 trustee believe that legislative intent was not clearly enough expressed and are challenging the exemptions, the increased homestead exemptions for these debtors in a number of proceedings in the bankruptcy courts now. The legal issue in a nutshell is that if a statute does not clearly state that it's intended for retroactive use, it is deemed to be applied only prospectively, which in this case has been construed to mean only debts that arise after its effective date of October 1, 2021. And if the bankruptcy court does rule that way, it's going to have a devastating impact, not only on the debtors who have already filed, hoping to use that exemption and thinking they could, to any other prospective Chapter 7 or Chapter 13 debtors that are trying to use that exemption. So when I came here today to testify regarding HB 5464, I came in favor of the general concept, but like Ms. Sternberg emphasized that the language does not go far enough to conclusively determine that issue. And unless we can lock this down now, is going to generate expensive litigation and uncertainty literally for years as to which debtors can use this increased homestead exemption. A point I'll make is that while one bankruptcy court is about to rule on this issue, we have 3 seats of 3 divisions of the bankruptcy court here in Connecticut. And while they will often agree, they also often don't, and certainly don't have to. So while one judge may agree with that interpretation that it can be used retroactively right now, another judge in a different decision in a later case may believe otherwise.
Attorney Chairman?
Yes.
Your time is elapsed. If you could summarize.
Yes. In summary, I think that the language of HB 5464, while well-intentioned, I think needs to be changed to be very specific and clear to anyone that looks at it, that the statute should be applied retroactively. It should be applied to all debts, past, present, and future, so that any debtors that file their bankruptcy cases can use that exemption as to all their debts right now without fear of losing it. Sorry, I'm finished.
It's fine. Representative Fishbone.
Thank you, Mr. Chairman. Good afternoon, Attorney Charmoy. Did you have a relative that taught bankruptcy law at Quinnipiac?
Yes, my father, Ira Charmoy, who is actually a pretty legendary bankruptcy practitioner, and I was fortunate enough to practice with him for many years.
Okay, and I was fortunate enough to take his class. But anyway, the intent, well, at least from my perspective, when I hear retroactive, what I don't want to have happen is a bunch of files have to be reopened because we're going to apply the exemptions to already closed cases in the bankruptcy court and change all of those. That's my concern with retroactive in the context of the exemptions. I don't know if the other members of the committee, share that concern, but when I hear that in the context of what we're doing here, do you agree that, as was presented before, that carve out that was in the prior legislation is not the same as what we're dealing with here?
Yes, Representative, I do. When the exemption first came into existence in 1993, we had no previous homestead exemption. So the legislature had its reasons back then for limiting the applicability only to claims that arose after its effective date. That is not the concern now. We've had the homestead exemption for 28 years. It is a procedural mechanism. As Ms. Sternberg mentioned, the bankruptcy rules change the exemption amounts every 3 years. So I think it's a completely different circumstance. To address the point with which you open, there is bankruptcy law that provides that exemptions are determined as of the filing date. So I don't think that there's any risk that someone could somehow go back into an older bankruptcy case and use an exemption that existed as of October 1 of 2021 and go back into an older case and try to use that exemption. If the legislature maybe needs more assurances, they could probably draft something that makes that clear, that you can't go back into an older bankruptcy case and use this exemption, but any bankruptcy case filed post October 1, 2021, you absolutely can use this exemption against all your debts, past, present, future.
Yeah, maybe we could, but right now I don't see a problem other than the dispute that's being created by the trustees. So we march on, but I thank you for coming here today.
Yes, thank you. Thank you for having me.
Thank you, Representative Fishbaum. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us this afternoon. Enjoy the rest of your afternoon.
Thank you very much for having me. Appreciate it.
Susan Williams.
Good afternoon.
Good afternoon.
yeah.
You may take.
My volumes, you can hear me, correct?
We can't hear you. You may testify.
Okay. Thank you. Thank you. Good afternoon, all. I'm here today, and I'm just really reiterating what my esteemed colleagues, Scott Chamoy and Jenna Sternberg, have presented to the committee. My name is Susan Williams, and I am a consumer bankruptcy attorney practicing law for 31 years in the state of Connecticut. And I did have the privilege of appearing before the committee when the House Bill 6466 was proposed last March, and we were seeking to have the homestead exemption increased from 75,000 to 250,000. And once the legislation was passed, I was actually delighted, appreciative, and grateful that our homeowners now had the opportunity to take advantage of the increased amount. Then, as Attorney Sternberg indicated, afterwards, there's confusion upon the interpretation as to whether or not the homestead will be applied retroactively or prospectively. And I had assumed at the time, and I think we all did, that it would be retroactively, and debtors that would be filing petitions immediately would be able to take advantage of the new increased homestead. And I think what I'd like to emphasize, because my colleagues have covered all other areas, that you need to understand that the debtors that are in financial dire straits today will never be able to take advantage of this increased homestead exemption if it is not deemed retroactive. The exemption will only apply to new debts incurred on or after October 1st of 2021, and those debts have just begun to come into existence. So the people that are struggling right now will not be able to take advantage of that. I was practicing law back in 1993 when the new homestead came into effect, and it was 75,000. And Debtors Council was tasked with that difficult task of trying to determine what debt was incurred before October 1st of 1993 and what was incurred after of 1993. No easy task, although it seems like it may. And I think it's very confusing, and it is something that really needs to take effect immediately to benefit the homeowners in the state of Connecticut. Thank you.
Thank you, Attorney Williams. Sorry, I almost called you Attorney Susan. Attorney Williams, for joining us. The comment or questions from members of the committee. Comment or questions from members of the committee. Not Attorney Williams, thank you very much for joining us to offer your perspective. Enjoy the rest.
Thank you.
Thank you. Ann Manusky, followed by Sarah Porson. And for those who may be on who weren't here when they were called, I will go back and give you an opportunity at the end, which we are approaching. Ann Manusky, Sarah Porras, C. Marcella. So, yes, you may
Hi,
testify.
Senator Winfield. Members of the committee, thank you for the opportunity to speak today. I'm grateful that you raised the bill 5468. I support this bill because inappropriate communication from an adult to a minor must be illegal. I pray that upon the passage of this bill that sexual grooming and abuse will be prevented, and that if these shall occur.
And which I'm sorry, which bill number did you say you're testifying on?
5468.
Mr. Chair, that's not on our agenda today.
My fault. So I posted about the bill, and I did indicate that the public hearing was today.
Ms. Marcella, that bill actually has its public hearing on Monday.
That's for Monday.
Yes, yes.
Okay,
So
I'm
if you
very
could-
sorry.
No, do not be sorry. We are glad you are willing to participate, and we will be happy to hear your testimony, but it's appropriately on Monday, so I hope that you are able to join us on Monday. If you're not, certainly please provide written testimony.
Okay, I will.
Thank
Thank you so much, Senator
And you,
Winfield.
you enjoy the rest of your day.
All right.
Uh,
Thank you. Goodbye now.
Jonathan Scher. There you are.
There I am. Good afternoon, Chairman Winfield, Chairman Stastrom, and ranking members of the committee. I'm John Scher. I'm the Executive Director of the New England Convenience Store and Energy Marketers Association. I'm testifying today in opposition to HB 5463. And I assume we're holding the hearing today because, at least in large part, due to the historic volatility we've seen in the motor fuels markets. Our association, Nexima, represents convenience retailers and wholesale motor fuels distributors in Connecticut and across New England. So this bill would directly affect both our wholesale and retail members. We are opposed to the bill because the definition of unconscionably excessive price is poorly defined and uses the term gross disparity as the trigger, but nobody can seem to define what gross disparity is because it's vague and it's subjective. Earlier today, and I guess this is one of the benefits of kind of going last, you get to hear everybody. Earlier today, Attorney General Tong said it's not defined in the statute, but it is fairly obvious that it represents something significantly different in degree and price. He also said his office makes determinations all the time, but it's up to a judge and jury, of course, to decide if in fact it was gouging. So is it 10%, 5%, 30%? I don't know, and I fear that nobody else really does know because of the subjectivity of the definition. And so, while lawyers and judges may have a lot of experience with unconscionability, and retailers do not, nor does the average citizen. So, and I assume any Connecticut resident would have standing, to make an accusation that would be actionable. So I was actually shocked to learn that the AG's office has had 750 individual price gouging complaints. And to me, that spotlights the low bar for making a claim. It was also said that retailers are frustrated by their suppliers' activity. And so I have not, from my membership, heard that from any of our members, nor do I ever remember thinking it, quite frankly, when I ran my family's wholesale motor fuels and convenience business for 15 years, where we marketed from Maine into the mid-Atlantic, including Connecticut. So the public, they see high prices and perhaps variation from one retailer to the next. And most likely there is a very good rational reason for it, particularly in times of volatility. But the claim is made, the investigation is open, and the retailer or the wholesaler is immediately in a defensive posture and has very likely had its reputation damaged. It's just not fair. The very best manner to prevent gouging, both in the retail and the wholesale level, is competition. And fortunately, there is ample competition at both levels in the motor fuels and convenience industries. But if a statute is to be created or expanded, retailers and suppliers really just need clarity and the least amount of subjectivity possible. Thanks, and I'm happy to take any questions.
Thank you very much. Senator Haskell.
Thank you so much, sir, for your testimony and for your thoughtful consideration. I don't disagree that competition is critical in terms of protecting the consumer and bringing down prices, but it seems to me that the legislation before us is tailored to circumstances where there is a declared emergency. And those would be scenarios where it would feel to me as though the customer maybe didn't have all the options that you outlined in your testimony, right? If there is a declared emergency, presumably they can't drive over to the next town to find that gas station. So I just wanted to sort of push back a little bit on that and get your feedback on the fact that competition isn't as available, I think, on a day of a declared emergency as compared to just a regular Tuesday in Connecticut.
So I'm just, why would that be the case in a declared emergency? What would prevent a consumer from identifying options in the motor? And again, just in the convenience and motor fuels industries, I certainly can't speak to every industry under the sun.
Well, it's hard to predict what is the cause of that emergency, but I do think that there are some scenarios that prevent drivers from traveling from town to town. I know that during my time in office, there was a declared emergency due to the number of trees that were down in the area. So they couldn't travel as far as they typically might, and therefore had less competition when it came to gas prices.
Yeah, I guess I understand that question. I think that's exceedingly rare. Also, just to let you into the mind of a retailer, I don't think retailers are thinking, okay, there's a declared emergency, therefore I have this group of customers that are that can only come to me, and therefore my prices are going to remain artificially high. Whether it's a declared emergency or just an average day, you're basing your prices based off what your competition will allow you to do and what your prices determine that you can do as well. So I hear what you're saying. I think that is very, very rare, and I don't know if expanding or creating statute with this level of subjectivity is justified given how rare that circumstance would be. But I answer that question with the most respect.
Fair enough, sir. Thank you so much. I appreciate the time of the chairs. I won't ask a follow-up question. I just want to, say that for the folks that I represent who are frustrated by high gas prices, I think that that there's a cause for that frustration. And in your written testimony, you say, competition is the answer and there is ample competition. And that would seem to imply that there is no problem. But in your own oral testimony, you mentioned that there have been over 700 complaints of price gouging. So I think there is a problem here. Maybe this bill isn't perfect. I don't pretend that it's the solution to the problem, but I don't think that it's only competition, because to your point, we do have competition, and I don't think that it solved the problem. Just my 2 cents. Thank you for the time, Mr. Chair.
Thank you, Senator Haskell. Representative Blumenthal.
Thank you, Mr. Chair, and I'll try to be brief as well. First of all, thank you, Mr. Chair, for being with us today and for your testimony. And I was just wondering, are you an attorney, before I ask any more questions? Okay. All right. So you saved yourself a little bit there, because I don't want to ask any unfair questions. I guess what I would ask is similar to what I asked a previous witness, which is, we have a federal False Claims Act, talking about the wrong thing. I guess the question I would like to ask is so about the generality or specificity of the provisions. I think you would agree, probably even without, deep understanding or knowledge of legal matters, that we make laws that all the time that are factually dependent on their application. We can't describe, for instance, like if for a fraud statute, we can't describe every situation in the bill. Fair enough. Would you agree with that? That there are other situations that are factually dependent?
That are factually dependent on, on various facts? Okay, sure.
Yeah, I guess what I'm asking is, I'll just represent to you that there are areas of the law where we'll say you can't engage in fraud, and we'll say roughly, what fraud means, and the legal terms will have application in a court of law, and they're understood in a court of law, and they're factually dependent. And I guess what I'm asking is just, why is this situation different in the price gouging context, rather than all these other situations?
Yeah, thank you, Representative. So I would say, how is a retailer to know, or even a wholesaler to know what that is, what that structure looks like? And because it's so variable, right? And it might be somewhat broadly or vaguely determined within the law, but not within actual practical, mechanical, day-to-day business operations. And so to that end, anybody could make a claim on anything. And so I don't know how a business operates within that structure.
Okay, I guess what I'm just asking is, for instance, we have a law that creates liability and punitive damages for highly unethical business practices, and it doesn't really go any further than that. And I'm sure you're probably not a fan of that law necessarily, but businesses have been able to function in Connecticut under that regime. And I guess what I'm asking is, do you see a difference from that sort of law to this one? And if so, why?
Yeah, I can certainly see, and you're right. I probably, immediately my instinct is to have problems with that. But that said, I know that there are businesses that act badly, and there needs to be ramifications for that. I get that. Again, I can only speak to what it is that I know well, and that is this industry. And I can certainly understand, particularly now. I've been in the press a number of times over the last couple of weeks trying to explain the volatility, but to the average consumer, most of whom buy gasoline or diesel at some point, or buy products that were delivered by gasoline and diesel and have seen some degree of inflation with those products. We see it when we see rational behavior change when there's a snowstorm. People run out immediately and fill up their tank, or buy eggs and bread and milk as if they may not ever leave their home again. But, we're here in New England, we know that within a couple of days, things are going to be back to normal. And so I'm very sensitive to people's changed behavior when they see something that they use every day change in price. And look, honestly, the prices have been changing wildly, and in some cases multiple times in a day, but there are valid reasons for that. But the average consumer couldn't possibly understand how the RBOB market is influenced by the futures price of Brent crude and the cash price in New York Harbor. And I certainly wouldn't expect anybody to know it. But the challenge with this statute is that it gives them standing to bring an action against those businesses that are almost every single time acting responsibly. But this opens a door where that business is an immediate defensive posture, and really, and it's quite sad, but in the age of social media, word goes out. This business, particularly, this individual business might get a black eye, and it could damage their reputation in perpetuity. So that's the trouble with the vague and subjective nature of gross disparity.
Okay, and I'm sorry, Mr. Chair, I just have one more question. If we were to put in some more specific term, a numerical term, would that assuage any problems you have with the bill, or would you still have opposition to it?
I'd have to look at it.
Okay.
I'd certainly be willing to.
All right. So I guess, is it just, it would depend on the number or the definition? There would be some version that you would be amenable to?
I prefer not to deal in hypotheticals, but I'm certainly willing to work with anybody that feels that this is necessary.
Okay. Thank you, Mr. Chair, and thank you, Mr. Chair.
Thank you, Representative Blumenthal. Representative Fiorello.
Thank you, Mr. Chair. Thank you, Mr. Chair. I wanted to ask you, the businesses that you represent, how do they decide to raise prices? I grew up as a daughter of my mother ran a coffee shop, and my mother did not like to raise prices because her customers would notice if a bagel was $2 one day and then $2.25 the next. So I was just wanting to understand from you, what is the thought process of your clients in terms of how easily they raise prices on their customers?
So I want to be careful that I don't bump up against any issues of antitrust. We get very, very skittish when we talk about prices, particularly motor fuels prices. I can speak to you generally and say it is a function of what the market will bear and what the price is, what the wholesale price to them is, alongside what their operating expenses are. Like your family with the coffee shop and not wanting to raise prices, I can tell you that by and large, retailers don't want to raise their prices to their customers either. It only brings uncomfortable conversations. Our members want to deliver a fair product at a fair price, and so that's going to be a function of those items that I had described. But certainly, every retailer is different. Every retailer has a different set of circumstances, but they still need to operate within their competitive landscape.
Right, and I think, can you speak for also not just the gas distributors, but convenience stores, right? Mm-hmm. So that's like sandwiches and bottles of water and
sure, all the above, coffee, fresh
Right.
food, you name it.
Right. And so one of the things that I'm really concerned about with this bill is that I do believe that business owners care about their customers. And especially when it comes at a time of a disaster or an emergency, I think that, they want to, there's the pricing mechanism, which I spoke about in an earlier testimony, is really important. And we don't want a bill that's going to interrupt what signals pricing mechanisms send. And I just wanted to understand, can you speak more about how, what would make your honest business guys raise prices in an emergency?
So I actually heard your conversation with Attorney General Tong about that. I found that conversation fascinating about how prices send a signal to the marketplace about supply and demand. I love economics. I found that a very interesting conversation. What would cause a retailer to raise prices on any number of on any product that they sell? As I said, is almost always going to be the price that it gets sold to them at, alongside what their competitive landscape is allowing them to do, whether it's up or down. And most times, it could go up or down just as easily. So just take the motor fuels market. If somebody in your market lowers their price, whatever, because they got pick a number, because they were fortunate enough to buy motor fuel on a day where the market was down, and as a result, their prices went down. A competitor was going to have to make a very difficult business decision. Do they change their price? Do they not change their price? But these are the daily gymnastics that every retailer goes through on any number of SKUs that they have in their store, including motor fuels. Every single day, this is how they spend their time.
Right. I appreciate that. And we want to be a state that helps businesses do their business, and we don't want to pass laws that hinder enterprise. And I appreciate you trying to help us understand that the price that businesses set is very much dependent on the price that they themselves had to pay. And they're not set willy-nilly. Okay, I think that's really all I really wanted to understand is the perspective from business owners on how they do set their prices.
And Representative, if I may, because you didn't ask it, but you touched on it, and earlier, when Attorney General Tong was speaking, he said that this would allow the state to kind of go up the food chain, so to speak, to the supplier level. And so I don't want to leave the impression on anyone that the retailers are innocent in this, and that we need to be looking at the wholesalers. There is just as much competition. Again, speaking in my industry, and I imagine it's the same for most industries. There is ample competition, and I briefly mentioned it in my testimony, there's ample competition at the wholesale level as well for milk, for bread, for motor fuels. And so a retailer is very infrequently bound by any one wholesaler that chooses to go off the rails, so to speak. So we often see the retail, because it's a consumer face, it's a B2C, right? We see the consumer facing products, and certainly for those, like you could buy a Coke, you could buy a Pepsi, you could buy an A&W, right? If the price is moved on, you have choices there. And it's very much the same from the retailer to the wholesaler level of that B2B relationship. So I just don't want anybody to leave I don't want to leave my testimony without having made that point. I don't want anybody to be unclear. So I felt it was important to make that distinction.
Right. And sorry, one more question. I do think that many of us could say, listen, if you don't engage in these kinds of price raising extremes for whatever reason, you're going to be fine. You're not going to hear from the Attorney General. So we're going to pass this bill really to get to the bad actors. But you have to go back and tell all of your clients, of whom you represent thousands of businesses, it looks like. So what message does
sorry, it says 1,700 convenience stores employing 25,000 people. What message does it send to them that we passed this bill, but listen, if you're fine, don't worry about it, but we have this bill on the books? What does that mean to your clients and business owners?
I don't know how that, I think it would be very confusing and very off-putting. I think there'd be an awful, I think Chris Herber, you heard from earlier, and represents a number of businesses in the state, as well as myself, would have to answer all sorts of questions we don't have the answers to. You know, how do I behave in this? What about this? What about that? And unfortunately, this bill doesn't give us good direction, which is why we oppose it. So, you know, if it was perhaps, and again, I don't like dealing in hypotheticals, but my concerns were, at least I'm certain, would be different if there was structure around it. But this one just doesn't offer that level of structure. So I don't know what I would say. Certainly, I can tell you that there would be lots of questions and a lot of uncertainty about how to maneuver going forward, which is dangerous.
Yeah, I understand that. I think what also would bother business people is that there's a premise in this bill that, you know, that you start at the place of like, can't trust business owners and gotta watch them. And I think, you know, I think business owners care about customers and vice versa. But thank you so much for your testimony. Thank you, Mr. Chair.
Thank you, Representative Fiorello. Comment or question from other members of the committee? Comment or question? Seeing none. Mr. Chair, thank you for joining us this afternoon. Next, we'll hear from Diane Lauricella.
Thank you very much. I know it's a beautiful day, and so I will be very brief. Thank you for allowing me to testify. Co-chairs, vice chairs, ranking members, and distinguished members of the Judiciary Committee. My name is Diane Lauricella. I'm here today to testify on Senate Bill 361, an act concerning probate court operations. I happen to live in Norwalk. What I'm about to discuss does not occur in the probate district in Norwalk. We have a wonderful judge right now. Due to a horrible experience in a Connecticut probate court in my late mother's district, I offer what I do not see in this bill, or I'd like some amendments to be considered as either in this bill or a concept for consideration next session. Number one, there's a great need for better public education component included in this bill to make sure that there's a user-friendly flyer laying out the entire process given to all people involved in each of the probate, so that you have consistency across all the districts, that heirs and executors are not subject to the abilities of the probate judge. Even though I know they are elected, we know at times the public does not do their homework when they do elect someone. Probate is not a user-friendly process for laymen. You're not supposed to, according to online explanation of the Connecticut probate process, you're not supposed to need an attorney for simple cases because the probate judge is there to kind of be the traffic cop. But this process often is conducted during some of the most highly stressful times, for instance, after a family member dies, and is very hard to understand. There's a lot of emotions involved. Number two, there is a need for additional beneficiary rights during estate management by both executors and the trustees and heirs, including a mandated notification to all parties that a mediation system exists. This mediation system was created probably by this very committee years ago, and it is a good idea, but the folks must be told that it exists. The way the system is currently set up, a beneficiary, such as myself, of an estate must wait until the end of the estate settlement process to find out whether the executor and trustee have handled the management of the said real estate properly. Beneficiaries are almost always guaranteed to have to sue the executor, often a family member of an estate, because the accounting of the bills paid, contractors hired, real estate sold, only has to be revealed at the end of the process, not during the entire administration of an estate on an ongoing basis, where problems could have been resolved more quickly. This causes families to fracture as money and property may be mismanaged.
Your time has elapsed. I'm going to ask you how many more, because you seem to be numbering your points. How many more points did you have?
I just wanted to wind up. I am done with my points.
Okay.
Thank you. In my case, the Connecticut mediation system that was developed probably by your committee could have, if it had been revealed to all parties, it would have handled and helped my family, not fracture. Thank you for listening to my testimony, and I'm happy to answer any questions.
Thank you. And I see Representative Fiorello, your hand is up. Is that from before or is that now? I'm going to assume that's from before. Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon. Is it Ms. Loricella?
Thank you.
Did I say her name? Did I say your name right?
Yes, you did. Thanks.
Okay, thank you. So the mediation system, and you're not a lawyer, right?
I am not.
Okay. So my understanding of the mediation system in our probate courts is that all parties have to agree to be part of that process.
That's right.
So you would have some sort of notice to individuals that are possibly part of a case in probate court to have some sort of writing from the probate court saying you could do mediation. Is that what I'm hearing?
Yes, Representative Fishbein. Just the fact that there is a mediation system, then it's of course up to the parties to decide on whether or not they want to participate.
Okay, and you have personal involvement with the probate court system. You had some sort of decedent estate that you were involved with?
Correct, in the past.
And as part of that, were you able to access the online filing system?
For mediation?
No, for the decedent estate, your involvement in that case.
I'm not sure I understand. I did discover the mediation process by doing my own homework.
No, I'm talking about the online filing system.
Wasn't aware of that either, but I was not the executor. I was an heir.
Okay, you had notice of the perhaps bequest to you through a testamentary document. Well, I gave you a lot of stuff there.
Yeah,
so somebody left your stuff in a will, right?
Correct.
Okay, got it. And you said at the end that after the case was over with, then you would have to do something with regard to what you thought was bad stuff for the administration of the estate. Did I hear you correctly?
Well, what I am proposing as amendments is, again, it's a process issue, a process problem. Once the estate was signed off, I didn't have any, I could not afford attorneys during the process. So I believe there is a huge gap for public accessibility and laymen to understand this process during and even before a probate matter.
Okay, I understand. And
yeah.
Some of the stuff that we're discussing right now is not, I don't think it's in the bill, but I understand you're here talking in general about the system. But I also note that, you know, when a final accounting is submitted by the executor, everybody is supposed to get notice of those things. And certainly if there's an objection to something that's, referenced on the final accounting, our rules of due process or the probate court allow one to object. So I'm just trying to identify, other than education, right? I'm just trying to identify in the context of what we're here on today, what you would have us do.
Well, because I saw the title of the bill and I read the bill during the operations, in my case, and I've heard this from other people, but in my case, there was an objection to the materials or the disclosure of the list, and the probate judge ignored it or made the situation, I could just not afford an attorney. So the probate judge did not properly do their duty, in my opinion. And I think by that point, it was too late. It was so late in the process. So that is why, as far as operations, for probate to operate in a fairer way in Connecticut, we need to look at some additional amendments or changes, such as the two that I have put on the table today.
Okay, I thank you. I thank you for your testimony and
Sure.
your ideas that you brought to the table.
Thank you.
Mr. Chairman.
Thank you, sir.
Thank you. Thank you, Representative Fishbein. Comment or question from other members of the committee? Comments, questions, seeing none. Thank you very much for joining us this afternoon.
Thank
Please
you.
enjoy your
Have a
day.
good weekend. Bye-bye.
You too. Sarah Porce.
Good afternoon, everyone. Thank you so much for the opportunity to testify. I'm here to testify in support of House Bill 5413, an act prohibiting a party to a civil action from attempting to recoup the costs of court-imposed service fees from an opposing party. I'm an attorney in West Hartford. This year marks my 20th year as a consumer protection attorney, and I'm seeing in my practice this tendency for, well, I do mostly foreclosure defense and credit card collection defense. And what I see is the plaintiff's counsel, the bank's attorneys, condo association attorneys, law firms that do other kinds of foreclosures and other collection matters, they file their suits, and the court fee to start a suit these days is $360. And then when my client gets the bill, or when the costs are sought from the court, when the firm seeks a ruling to get its costs paid from the court, it isn't $360 that they're claiming. They're claiming something like $368.65, and that $8.65 surcharge represents this service fee that the courts impose. But I think it's unfair to then, for those firms who choose to use a credit card, right? The fee is only imposed when the firm who initiates the lawsuit uses a credit card to pay the court fee. Then that law firm passes that fee on to the consumer, the homeowner, the person who's in debt. Now they do so without itemizing out the service fee. So what I'm seeing as well, and I'm trying to prevent this from continuing, is the $360 service fee. I'm sorry, the $360 court fee. They add the service fee and they just call the whole thing a court fee. So not only is there an unfair additional cost that the homeowner, the consumer, the person in debt did not bargain for, but it's not even fairly itemized for the court or for the party who's being asked to cover that cost. So I think that this bill would prevent an opposing party from imposing that additional service fee at all onto a party who's already at a financial disadvantage.
Thank you, Attorney Porras. Representative Fishbein.
Thank you, Mr. Chairman. I'm just trying to get around the public policy that would be advanced in supporting this legislation. So the legislature's already spoken and has in effect said that the bank did not bargain for the foreclosure. And therefore, if there is a foreclosure, that court fees are going to be filed. Why just public policy? How does this initiative advance that public policy?
Well, the impact is seemingly small per person, but larger overall. If we look at the number of foreclosures that are filed, and it's sort of all wrapped in one. The law firm chooses to use a credit card versus another available method that doesn't have a service fee. Okay, so it's not like the law firm must incur this service fee and then is left holding the bag with it. the law firm could easily use an e-check version, which is what I use when I file court fees, when I pay court fees. But instead, the law firms are choosing to use a credit card now. So they are choosing to incur a fee, and they're attempting to pass this on to the opposing party. The opposing party isn't even aware that they may be able to raise an objection to it, because often when the filing party bills for the court fee, they add on the additional service fee as if that were the part of the actual court fee, which it's not. So I think it's unfair to not break it out, to give us an idea of how much is the actual court fee and how much is the service fee.
Well, isn't that very easily, I mean, because we know that the court fee is $360. Are you looking for the judicial branch to break it out so that there can be backup? I'm just, because I know when I file these things, I mean, they don't break it out. You know, this is the charge, right? That's how the judicial branch does it. So I'm just, is there some question that certain banks are not just passing down the fee that is imposed upon them by the judicial branch?
I'm saying I don't believe that that additional service fee should be imposed on the opposing party for multiple reasons. One, this is a consumer protection matter. Although it's a small amount, sometimes these additional fees can be the difference between a homeowner being able to save their home or not. For example, in a water or sewer lien foreclosure, in a condo fee foreclosure, those foreclosures generally involve very small amounts, $1,000, $1,500, $2,000 or $3,000. And the homeowner is not allowed to redeem their property unless they pay every dollar. And if they're a dollar short, the foreclosure can proceed. I know that sounds extreme, but that's what happens in practice. And so this extra $8 here and there can be the difference. And so hopefully I'm clarifying why I think it's a problem.
Well, you seem to be indicating that there was some question as to whether or not the service fee was legitimate, whether or not the service fee was actually being imposed, what the service fee actually was. And I'm just trying to get to, you know, why that's a question.
No, I understand where the service fee comes from, and it's posted in courthouses, and anybody who uses, who actually accepts credit cards like I do from clients, we understand we have service fees involved. What I'm seeing is that there's an unfair lack of articulation by the firms who choose to use credit cards to pay court fees, when they then attempt to pass it down to the borrower or the consumer or the homeowner as part of a bill of costs. In fact, they're not even accurately representing to the court when they seek these fees to be reimbursed that there's a difference between the $360 and the additional service fee. There's precedent in other areas of law about not properly identifying a cost or a fee or a tax when charging this kind of thing to a party, to a customer. And I want the law firms who use credit cards when they pay their court costs, I want them to do so in a way that's fair and transparent to the consumer who is ultimately going to have to absorb that cost.
So fair,
or for that not to be passed down at all.
Understood. So as an alternative, fair and transparent would call for on a bill of costs, one break out that fee as a separate line. That would be acceptable also for fair and transparency. That
would clarify exactly, so that it isn't so the consumer doesn't assume that the court fee is $368.83 or whatever the service fee comes out to be, but the $360, and then there's the service fee on top, and the court can decide whether they want to award that additional service fee to the filing party, and it's something that a consumer can object to.
Have you had an opportunity to, certainly if it says 368, you have the opportunity to object to a bill of costs. Have you asserted to a court, that's 360 plus 8 something, and the court has said you can't deal with that?
I did so recently in a trial, Your Honor, where the entire amount my client was asked to pay is a different kind of case. It wasn't a foreclosure, was purely made up of attorney's fees. And I cross-examined the attorney on the additional service fee. and the imposition of that service fee. And I asked the judge not to award that service fee. So I've raised it as an issue recently. Yes.
Okay, all right. Well, I don't want to belabor but I enjoy the conversation. So thank you, Mr. Chairman, for the opportunity.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? Seeing none, Attorney Porras, thank you for joining us.
Thank you so much.
I believe I'm at the end of my list, so if there's anyone left who was signed up to testify but has not, this would be your opportunity, but I don't see anyone. So that being the case, I believe we have come to the end of this public hearing. It's a good day in judiciary when we come to the end of a public hearing at 2 o'clock. Enjoy the rest of your weekend. Representative Stastrom, any comments before we finish?
I was just gonna say I'm glad to finish at 2 p.m. instead of 2 a.m.
Yes, much
2
better.
o'clock seems to be a magic number this week. I'm glad it's this 2 o'clock. So
We are all, I believe, happy about that. All right, everyone. We'll see you on Monday.